Excuse me. Excuse me. Everyone, please be settled down. We'll be starting in 2 minutes.
टेस्टिंग हो गया है ऑडियो स्पीकर पे बोली कालिदास की माइक्स है ना रेडी हो सर
There's no mic here.
वाटर बॉटल से प्लेस कर दी ओके ये क्या ऑडिबल है आप चेक करें एक बार उनको बोलिए इसे माइक को ऑडिबल है ये ऑडिबल ना और वो ऑडिबल है मुझे कुछ बोलने के लिए आवाज आ रही है ना से बात करते हैं कालिदास भाऊ एक हँड माईक तर ठेवा आणि हँड माईक द्यायला हँड पण ठेवा सर डायस पे कितना देते दो लोग देखिए नाम देखिए
Excuse me. We'll be starting the session now. So we've had a very fruitful first panel discussion here. And we've touched upon some topics such as Napster and the issues which music industry faces considering royalties and all of that. And this session is dedicated only towards music industry. The session is titled Copyright and the Music Industry. For this, we have 3 amazing panelists here and Aparna Gaur as our moderator. Aparna is a leader at the IP and TMT team at NISHITH, DESAI and Associates, and she's also a registered patent agent. An experienced advocate, Aparna is active in IP transactional and advisory work. She has vast experience of advising clients over a wide spectrum of industry in relation to protection and enforcement of their IP. Today, she'll moderate the second session. We welcome you, Aparna. Our first panelist here, Pragyan Sharma, is going to be present with us virtually. Pragyan Sharma is an independent legal counsel and he appears regularly before Supreme Court, Delhi High Court, and various other high courts and tribunals all over India. He has a wide-ranging experience of over various fields of law such as power, automobile, and media and entertainment. This by no means is an exhaustive list. He has extensive experience in handling matters for PSUs and government of India and various states, including matters in standing capacity of capacity of standing counsel in the Supreme Court of India. Welcome you, Pragyan. Our second panelist here is present physically with us, Pooja Uday Bakshi. Pooja is the head of legal team at Sony Music Entertainment Private Limited. As the legal head, she has dealt with many matters regarding music industry, and she's someone has been adapting rapidly to the constantly evolving field of music and media and entertainment landscape. As an individual who has dealt firsthand with various issues, she'll be a guiding light for us in this session. We welcome you. Our last panelist, Atul Churamani, will be present with us virtually, just like Pragyan. Atul is the managing director of Turnkey Music and Publishing Private Limited, a company which was founded by. He's a veteran in the music industry and he has been closely associated with the development of Indian pop music scene and establishment of digital music publishing business for the industry. One only has to look at the illustrious career in which he has launched the careers of artists like Baba Sehgal, Daler Mehendi, Shan, Colonial Cousins, and many more. He'll bring a wealth of experience to our panel today, and we are welcome. We are very happy to have you here, Atul. We welcome you. With this, I would hand the dais and podium to Aparna. And
a round of applause for all the speakers.
Yeah. Aparna.
Hi everyone, thanks so much for joining us. Yeah, it's on. Yeah, thanks for joining us. We will be talking about issues, faced by the music industry with respect to copyright. Honestly, when we thought of having this session, when we thought of a music session, we really thought that it's something, there's so much that's, not clear with the law that we can do a full one-day workshop on this, but we'll try to cover as much as possible within the 1 hour that we have. Atul, unfortunately, is unwell and he's lost his voice, so he will not be able to speak, but he's been kind enough to share some thoughts with me on email, and I will be sharing them with you during the course of the discussion. So I'll begin with the session, and since we have some students also with us, I'll start with Pragyan. And Pragyan, I'd request you to maybe deal with just the basics of when we talk about a sound recording, right? Who are the different stakeholders that we're talking about, and what exactly are their rights when it comes to exploitation of a recording?
Hi, good evening, everybody, especially Pooja. Thank you, Gauri, for making me a part of this amazing seminar. So really nice of you. So I think you have asked me two questions. The first being stakeholders, who are the stakeholders and what are their rights to primarily. So coming to answer the first question as to who are the stakeholders, we would first have to understand what is a sound recording. So sound recording is basically not a copyright as such, but it is a derivative right which has been deemed as a copyright under the Copyright Act. Okay, so therefore we have to see what are the actual copyrights in a sound recording. Now, so these rights which are within the sound recording are known as what are the underlying rights, and I'll come to that issue. It's a separate question and a separate issue altogether. So the underlying rights that are there are the literary right and the musical right. Okay, so now the stakeholders in terms of section 2D primarily would be therefore the authors. Now there are different authors or different category of people who are the authors as far as the sound recording is concerned, and as far as the literary work and the musical work is concerned. So as far as the sound recording is concerned, because the sound recording is created by the producer in a studio, so therefore the producer is the owner of the sound recording. Okay, so there is no doubt about that. As far as ownership is concerned, undisputedly, it is the producer, or from the producer today, the music companies. Pooja is smiling all the way to the bank. So they are the owners as far as the sound recording is concerned. However, what has happened as now, and as far as the literary work is concerned, it is the author, the person who writes the lyrics. For example, in a song, say Javed Akhtar Saab is the author of the lyrics. And when you come to the musical rights or the composition, it is the composer. So therefore, technically, in a sound recording, there are three kinds of stakeholders as such. And why I say stakeholders is because of the 2012 amendment, to which I'll come later. But as an industry practice, there were two categories of music. So one is the Bollywood music or the film music as we understand, and thereafter there is the private albums. Okay. Now, as an industry practice was what used to happen earlier, the producers would take assignments from the composers and the authors and get the entirety of the rights as far as the music is concerned. And these rights were thereafter transferred to the music companies for exploitation in their way. So, therefore, in terms of Section 17, for the entire gamut of rights, the producer or the music company became the complete owner. Because unless and until there is a contract to the contrary, which from more or less there were none, till people like A.R. Rahman, etc., has come in, all the there were contracts to the there were no contracts to the contrary, and being all these contracts being contracts of employment or contract of service, as they say, therefore the producer became the first owner and had ownership of the entire gamut of rights. Now, interestingly, what has happened in the 2012 amendment, an interesting proviso was brought in to Section 18 of the Act. Now, as you all know, Section 18 deals with the right of assignment and under what circumstances assignment can be done. Now, what it did, it brought in third proviso and the fourth proviso to the Act under under Section 18. Now, the third proviso dealt with the sound recording in a cinematograph, and that is basically the film music, as we say. And the fourth proviso had the sound recordings as far as the music which was outside the cinematograph, the private albums. So what it basically said is that it should not, basically what I'm trying to say is that if you can just pull out that the third and the fourth proviso, it will make things very clear for the participants here. Yeah, so slightly above that, yes. If you come to the, yes, that's the one, that's the one. You can go down slightly so that both the pages can be seen. Yeah, this is the last one at the page is the one that deals, this is the third proviso that I was talking about, that deals with literary or musical work included in the cinematography. Now, what is the underlying fact here? What it says is that the person, if he assigns it to any person other than his legal heirs, that shall be void. And if you go to the one below that, that is the fourth proviso, it says the person who's assigning, he has, even though he assigns, he cannot waive his right to receive royalty. And in case there is an agreement to waive off the royalty, that agreement would be void ab initio, or that agreement would be void. So therefore, what it entails is that for exploitation of the sound recording, the royalties for that exploitation would be shared on an equal basis with the assignee of the copyright. Okay. So therefore, in terms of these two provisions, the law has come to more or less settle, or the practice has come to more or less settle, that the producer or the music company is the complete owner of all music. But in terms of royalty, or the, if I say the stakeholder in a way, the author and the composer would be also a stakeholder, maybe with a lesser right, that is of the right to receive royalty. Okay, so these are the, so basically, if you therefore ask to answer your question, technically the first right is of the producer or the music company, and the second rung of stakeholders would be the authors and the composer, who are the literary owners of the authors of the literary work and the musical work.
Thank you for that, Pragyan. One more follow-up question to this. There's also performers, and the Copyright Act specifically recognizes performers' rights. And with respect to music, obviously there's singers who are there, and there's copyright societies dealing specifically with rights of singers. We wanted to just deal with that aspect as well, and what exactly are the rights of performers with respect to a sound recording.
Very interesting, because there's been a lot of developments. And Pooja, if you can take out the definitions of performer and performance in 2Q and 2QQ. I'll start from there actually to answer your question, because this is something very, very live and something very interesting, because the litigations in the Delhi High Court with regard to performers and rights have just been settled. The music companies have withdrawn, or ISRA has withdrawn those cases. 2Q. So first I will come to 2QQ, and then I'll go to the right of the performer. So if you see, who's a performer? Now, performer can be a singer or a musician, but please underline the words who makes a performance. So that makes the definition of performance very, very important. Now, what does performance say? Performer in relation to a performer's rights means visual or acoustic performance made, please underline this, made live by one or more performers. Now, the question therefore is, if it is a live performance, it is only in those circumstances that a performer's rights, which is there under section 38, kicks in. Now, we all understand what is a live performance. Live performance is when you go onto a AC/DC or a Guns N' Roses concert, or a concert of, we went to a Jugalbandi concert of Amjad Ali Khan and Zakir Hussain. So that is a concert. That is a live performance. So the recording that is done in that live performance, the performer has a right for any exploitation of that. Okay? But what happened? The 2012 Act brought in certain interesting changes in the way the performer's rights were to be interpreted. And just see, therefore, section 38. Section 38 with some amendments have been made. There's some amendments that have been made. But what is important is 38A. Where specific rights have been given to the performer under the 2012 Act. 38. Now, as you all know, performer's right is not a copyright. It is like a moral right. It is a special right that is being given to the performers under the Act. Now, just go one step above into section 38 per se, and then we'll come to 38A. Yes. 38, yes. 38, yeah. Where a performer appears or engages any performance, he shall have a special right to be known as performer's right in relation to such performance. So if you see, if you go back to the definition under 2Q, this performance, please mark again that it is only a live performance. Okay, now let's read performance. What are the rights of a performer? 38A, therefore. Now, so it's interesting. Therefore, what it says is without prejudice to the rights conferred on authors. So, the author's right, okay, that is maybe a producer's right, or the the author in a musical work, that is the composer, or the author in the literary work, their rights, protecting their rights. So their rights has a prominence here, and without obstructing their rights, the performer's rights will come into play. Okay, that's my interpretation, and that's probably the manner in which we have to read section 38A. So is an exclusive right. It says that is an exclusive right to do or authorize the doing of the following acts which are there specified in A: to make a sound recording or a visual of the performance, including communication to public. Okay. So, and if you see subclause 2 says if it is, now if you see, the performer has by agreement consented to incorporation in a incorporation of the performance in a cinematograph, then the producer will have all rights in the film. But then, if you see the proviso to that, the performer shall be entitled to royalties in case of making a performance for commercial use. Now, interestingly, what has happened now is that if you read the act, the intent of the legislature while making this act seems to be clearly that the royalty or the right of performers kicks in only in respect of a live performance. Okay? But interestingly, what the copyright rules that came in 2013 did, it sought to expand the definitions or the scope of Section 38A. Probably that was the intent. But they did not change the definition of a performance in this thing while contemplating Section 38A. Just see the rules. If you have the rules with you, do you have it? Yes. So just take out Rule 68 for a moment. It's very interesting. Therefore, I want you to refer to that actually. So go to the 3 explanations which are at the bottom of this. Okay. So the first explanation says that royalty collected from the enjoyment of a performer's rights so and so shall be shared equally between the performer and the owner of copyright. No difficulty with that. So therefore, only with explanation 1, what happens is that the performance which is live, any royalty collected out of that gets shared between the owner, that is the producer, and the performer. No difficulty qua that. See the second one. Now, commercial use also means exploitation by way of reproduction, by communication to public by broadcast. Okay. Now the question is, if it is only live performance, where is the question of bringing in communication to public by broadcast? Because when you bring in communication to public by broadcast, you are departing from the rule of live performance. You are getting into a studio kind of a recording. And that is what is clarified again in explanation 3. Again, very interesting. It says for the purposes of this chapter, performance includes recording of a visual or acoustic presentation of a performer in the sound or visual recording in the studio. So it does actually, the rules of the explanation, what it does, it has expanded the scope of the whole gamut of the right of the producer. The question therefore that arises, and it's very interesting, that can the rules expand the definition or the scope of a right which is provided under the Act? We have several judgments of the Supreme Court which clearly say that the rules cannot expand the meaning of the Act. So to my view, therefore, these rules are contrary to the Act. Now, exactly these arguments have came up before several litigations filed by ISRA and a lot of music companies like Saregama, Yashraj and T-Series filed intervention applications before the Delhi High Court. Now recently, and Pooja will clarify this because she has all the internal news and gossip, there has been a kind of a settlement between the various stakeholders, and I don't know what the terms of. Pooja will, if she has the authority, she will disclose all of that. So there has been a settlement where from the collections, the author and the performers will also get some kind of royalty out of the broadcast of the sound recordings. That's who are the performers.
Sure, thank you. Thank you so much. I think what basically comes out of it is there is definitely lack of clarity in the letter of the law. So Pooja, on that note, I'd like to ask you as someone from the industry, has the industry faced issues in implementing what the 2012 amendments brought in?
Hello? Hello?
Yes, yes.
Thank you. Okay, so yeah, that's true. Lots of things have happened post the amendment, and because of that, lots of issues have been faced generally, I think, by the industry overall. Taking from where Pragyan is left, I think it's important to probably start with performers since we're anyway discussing it, as well as whatever is related to the royalty payouts for authors. Okay, I think primary issues were these two, which actually, obviously, okay, let me put it this way. Three issues are really important. One is the term utilization that is there for authors and composers that has been used under 18 and 19. The second is related to the similar issue for performers. Once performers got introduced in, the issue came out as whether they are actually copyright holders or not, and what is the rights that the performers have, what is their level of rights that they have. Okay. Third is the issue of 31C and 31D. Now, these are the three variant major changes that came about, which have led to a lot of discussion, a lot of debate, and a lot of litigation to a large extent post the change of the Act. Okay. Starting with utilization. Now, I think the issue is that most authors face this problem, or let's say the industry is facing this problem on the interpretation of the terminology utilize in 18 and 19. It's so wide, it doesn't say clearly what it really means, utilize in which form. And now, like we discussed in the earlier panel discussions, NFT, etc. have all come in, right? So loads of modes of exploitation have set in. So what is utilization? Anything is utilization. Whereas if you look at it, I mean, maybe I'm kind of reducing it or just giving a simple sample of an example. If you look at it overseas, like a PRS, etc., when they consider utilization for payables to authors, they look at it from the performers or the communication to public concept. And that's how IPAB or anyone else has also dealt with it when they've introduced the royalty payouts on the 31D. Okay, but the issue primarily is that the terminology in the Act is not appropriate. It doesn't clearly restrict or say that is what it is. It's just very wide. So I think conceptually that is where I felt was an issue of concern. I mean, in the sense, obviously, it's a great introduction that the authors are entitled to royalty on all utilization. And that is, I think, always what the intent is. In fact, as a consequence of this, I think even the introduction on the mode of medium is quite redundant, because today there is a royalty structure set for all authors to be paid continuously, irrespective of whatever mode of medium is being introduced. So therefore, I don't see that sort of an aspect is of concern. But this terminology has led to litigation and a lot of interpretation. In fact, this has also led to the litigation where we are all under debate on whether sound recording entails usage of literary works or musical works or not. And that itself has become a bigger litigation, because today I think even in the broadcast section that is under debate, which ideally, since we all thought or believe that communication to public or broadcasting would entail a right, the very fact that that is being challenged today in Supreme Court or is under appeal is an issue of thought. And more so now, post the amendment of the Act, the interpretations as per 2012, I think even the earlier judgments were very clear on the fact that let's just read. I mean, Pragyan, I'm sure you can add on where the judgment issues are there. But I felt that the issue that which I thought we should just discuss is that definitely these are independent works. They definitely form part. The very fact that the Act is amended and now there's a royalty payout for it, that means there is supposed to be payment made when they're used. So to say that they are independent but we are not recognizing its existence when it's forming part of a sound recording, I feel that may not be the most accurate of interpretation, because let's assume it the other way around. Today, if you assume a literary work or musical work is infringed when creating a sound recording, you do raise an issue, right? Don't you say that, well, this is wrong. How can you use a literary work or musical work which is copyright infringing in a sound recording? Because you acknowledge the existence of that work in that sound recording. Similarly, to say today that that work isn't relevant is inappropriate. In fact, today, since there's a change in the Act, post 2012, it says there's payable royalty on the usage. That means they are also recognizing that it exists as part of a sound recording. Similar situation will arise when a sound recording is featuring in a movie. The same situation arises. So I guess that is one of the bigger issues that have arisen, utilization, the wide gamut. And the other issues also, when they say the word is equal. Equal to who? Equal to what? Assign what? It's also complex. I know I'm maybe mixing a few things here. It's a little complex vis-a-vis when you look at it from performers. Today you're saying performer will also attract 18, 19. So equal in what way? A performer has to be paid equal, author has to be paid equal, and a music label, who's a publisher, also has to be paid equal. Then how are you paying this money? clearly that aspect hasn't been really looked into from that side. Other than that, equal is something, equal from which aspect? Even a music label does not get equally all the money. Half money is retained at different levels, at different places for different levels at utilization. So when you say equal, at what source is it equal at? So there are lots of commercial angles when you say equal. I think that is one more aspect that should be considered. I think that's one of the things. Also, if you look at PRS or you look at how UK law treats it, right? There they clearly call it equitable remuneration, and they refer to it as performers royalty. And I think PRS is very clear that the royalty payouts on the usage is on performers. And I think that law is a settled law utilized by them for a long period. Their law, I think we have reached this sudden age, we've jumped 2-3 sections and we've arrived at our law, whereas they've graduated to it. So I think there should be certain learnings on our path, seeing how they have arrived and why they arrived at that. And also the fact that the quantumization of it, when we think of it, as to what percentage or proportion of it, that will all be dependent on the modes of utilization of how the performance happens. Example, it would be important for us to assume if streaming is there a higher level of performance in it, or there is a mechanical component in it, then therefore the performance royalty should be paid. If digital is a medium, is digital a medium? I mean, there are several aspects that need to be considered. Again, maybe because of that, and also Tips and Week is very clear that internet broadcasting is not part of 31D. Okay, taking it's a mix in my discussion. So if I'm heading from all directions, excuse me, you can always ask anything in that. But that itself will clearly indicate that the definition of broadcast, which is covering wired and wireless, and also that itself is covering communication to public, has led to this confusion in the interpretation, despite the clarity of 31D, which clearly says that it should have been restricted to the television and radio broadcasting. So, I mean, these are things which are open for interpretation, no doubt, but these are things which are currently there, which are a reason of dispute. Because of this, there are a lot of interpretation issues. And now, of course, this is the author level. The other bit I was touching was on performers. I think Pragyan just went in detail on the entire section on performers. If you see 38A, it's very clear. It clearly details out if you have a contract to the contrary, what is the position you should hold. It also clearly clears out what happens in a case of commercial use. That means there's a royalty payout there. Why is there a royalty payout there if you have an 18 and 19 section, which is supposed to be read for royalty payouts? And why is there this parallel royalty payouts? What is the implication or indication of that? If that is the case, and today you're treating a performer right to be on the same page as a copyrighted work, so it's not copyrighted work, because you're saying you can't apply 14 to it, quote unquote, because it's for copyrighted work, then in the interpretation, you've also put a section where you detail out what a performer right is. You also detail out how the exploitation of a performer right is. Then in that sense, how are you treating the interpretation for 18 and 19? And why is that on all utilization payable when that utilization clearly details out 38A as to what the utilization is or what that right is? I think that these are the sort of, again, issues that have cropped up, which are little interpretation related. Yes, today, I think because of all these issues and the global position also being different, worldwide, there has been some discussions with the industry and there's been attempt to arrive at something mutually so that it's convenient for working, like Pragyan mentioned, with the Singers Association, because the intent was never not to pay, but the intent is that how to pay, what to pay. There's a little vagueness in that, and I think that should have come out clearly somewhere. The third issue that I'm highlighting on is 31C and 31D as issues. Again, like I mentioned, 31D I already highlighted. The broadcasting is the definition which is of debate, which has led to a lot of interpretation issues, which has led to even there being circulars passed to clarify the interpretation. I guess that is of concern. Also, I guess 31C, it's great as an introduction to refer to what a cover version is in order to secure the rights so that there's no misuse of the rights of people and authors and content. But the concern is today, as per Rule 27, how are the rates being fixed, or what would be the rate structures that are payable to them, and what is the royalty that we have to pay for the 50,000 units if I want to make a cover version. And of course, I'll comply with giving a notice. Of course, it's mandatory that I should just give a notice and the rights will flow in. But if there's a minor adaptation, will the guy object? He may object under 57 anyway. But I'm just saying it's still vague. It's not the most appropriate because the rates aren't there and I can't use this section. So it's in play today. Within the industry, we've accepted the position that maybe we can't use it right now. So we ourselves would not be in a position to make versions. However, you can see a lot of versions floating on YouTube, right? But the fact is that those are UGC and those are treated as versions for which licenses are sort of in some ways paid by the platforms itself because they are envisaging that people will be using it. And that's how it's working today. But technically speaking, if I was to actually say, hey, I want to make that song and I really want to make it as a version to it, I'm today not in a position to do so since 2012 because I'm not really clear on how the rate will be fixed and what will the rate be. So I guess these were the real issues that we really faced on the industry level.
Thanks, Pooja, and thanks for breaking it into points, considering that we're thinking of making submissions to the government. I have one out of syllabus question for you. I'm sorry I didn't put this in the list, but since we've spoken about how rights, for underlying works are separate rights, what is your view on a separate license being required when a sound recording is being exploited for the underlying works as well?
So obviously this is in court currently and it's in big debate also. And I think there are two aspects to it. And I guess both may be right and wrong because of the way the reading is. But really section 13 of the act with subsection 4 clearly says that they're both independent rights. Okay. Global position is that whenever any work is used, the underlying works are paid for. So in view of that, I mean, contrary to whatever, I mean, of course, it's subject to whatever the final outcome would be in court. But obviously, if it's an independent work and it has a separate entity or a right, and like I mentioned, if for utilization you're paying, if for infringement of that work you're paying, then that underlying work has a value. And that work is an independent work without which you can't make the other aspect. So I guess in some ways, that ideally would be also recognizable and ought to be paid for. It's definitely paid for independently. It's different that when a cinematograph film is playing, people are not paying independently for sound recordings. They rely on cue sheets and stuff like that. But ideally, that ought to be paid for also separately. So.
Thank you. Pragyan, do you have any thoughts on this aspect about the license for underlying works? I think you're on mute. Sorry, Pragyan, you're on mute, I think.
So that's a very difficult question to answer considering I represented one thought process. But if you give me the brief for the other side, I can argue even for the other side. So I have no difficulty. But I'll basically lay out as to how the controversy evolved. I mean, that's very, very important as to how has the controversy of this underlying work has evolved over the years. Now, what had happened is this whole controversy dates back to 1977 when the Supreme Court, in a litigation filed by IPRS against two concurrent judgments of the Calcutta High Court, the division bench and the single judge, held that IPRS does not have any rights because IPRS consisted of the composers and the literary authors at that point of time. Okay, so IPRS consisting of music companies were not a part of IPRS at that point of time. Mind you, that's something very, very important. So they contested before the Supreme Court and said, when a cinematograph is exploited in a theater, my music or my composition is also exploited. So therefore, I have a right to royalty. Now, what the Supreme Court said, and as Pooja mentioned about section 13.4, because section 13.4 says there shall be a separate copyright. So technically, therefore, the cinematograph becomes a separate copyright. So putting reliance on section 13.4, the Supreme Court said that once you have parted by way of an assignment or otherwise, your rights and your right to show that music or composition in a cinematograph, you are devoid of any rights. Therefore, the producer will become the owner or not only the cinematograph, but also the music that is underlying in that cinematograph. Okay, so that's one aspect in the Supreme Court. Now, what happened? This controversies again started thanks to IPRS. IPRS had agreements with these various broadcasting companies like ENI or Radio Mirchi, Radio City, and all of that. So one of the points, and this was our creativity, we said because IPRS had given huge infancy discounts to these music companies, and they started booming into profits, etc. Says we should not be giving you all these discounts. These discounts are to be going out. And what they were doing, for example, if the music license was given for Mumbai, you could hear music of the same radio station up to Pune. This was before the second phase came in when Pune had a separate license, etc. So you say you are violating the term. This agreement was only for Mumbai. So when we raised those issues with the broadcasting companies, they came with a counterattack. They said, see, IPRS, you being an underlying work, we don't need to take a license from you. If we take the license for the sound recording, that is good enough for us. So that matter initially went into an arbitration and also became a matter before the Delhi High Court in a matter known as Aditya Pandey. Now, as far as the Supreme Court arbitration before Justice Sudhata Manohar is concerned, she held against IPRS to say that when a sound recording is exploited, the underlying works need not have a separate license. Because as Pooja said, once there is a new work, why do you need to pay for an underlying work? You don't need to, and that's the international practice, as Pooja rightly mentioned. Similar view was held as far as the Delhi High Court, single judge Justice Ravindra Bhatt's order. He also said a similar view, saying that, look, you don't need a separate license. Sound recording is good enough. And that view was actually upheld by the division bench, a judgment of Pradeep Nandajog and Justice Malhotra. Against that, IPRS filed a Supreme SLP in the Supreme Court. Now, Supreme Court, by a judgment of Justice Pant and Ranjan Gogoi, came out with a similar view, saying that no, you don't have a right, but see, the law has amended. It directed the single judge of the Delhi High Court who was hearing those suits, because all these observations of the Delhi High Court were interim orders. So you kindly dispose of the suit. Now, interestingly, what happened in that single judge, Justice Enlaw's judgment, he says that, look, IPRS, even after the amendment, although that was not an issue before him because he was dealing with a suit prior to the amendment. So he came up with the view that even after the amendment, IPRS would have no rights. Whereas the Supreme Court in its order had clearly stated and accounted for the provisions specified in section 18 and 19, which technically, more or less, as Pooja pointed out, the point of utilization, etc., it seems from a reading of the Act on a deeper interpretation that some kind of right on the utilization was given to the underlying rights also. Because that is otherwise it would make the word utilization completely redundant. So therefore, an interpretation or an argument can be made that once the sound recording is exploited, there is a utilization of the underlying work. Okay, so if there is a utilization of the underlying work, a license is entailed even for that. That is a separate license. And the Copyright Act at several portions say of licenses who are sound recording and licenses who are musical and literary work. So obviously, if you read the Act in a harmonized manner and as a whole, which is one of the rules of interpretation, then a sense I can argue, there is an argument that I can make out that separate licenses are required. Now, interestingly, at the same time, when the Delhi High Court order came, the IPAB, which was dealing with a section 31D issue, on on valuation as far as broadcasting is concerned, gave a view that yes, there has to be separate royalties paid and separate licenses taken both for both musical and literary right and a sound recording. So, and as Pooja said, this is an issue which is live and is now pending before the division bench. So you could argue it either way. So I am biased because I have come to represent a particular section of the music company side, but there are definitely arguments for the broadcasting side also. I don't say there are no arguments, and I think we had a very intellectual discussion. Gauri has a different view as far as this issue is concerned, and I'm sure I'll convince her over a cup of coffee whenever she's in Delhi next that probably the law, in my view, as far as India is concerned, because India jurisprudence is slightly, there is a departure from the US or the UK law. So as far as Indian jurisprudence is concerned, I feel, and that's my personal view again, the regime will settle down at two different licenses and the underlying works being licensed separately. That seems to be more or less the understanding amongst all the stakeholders also at the moment, presently at least. So that's where we are at the moment.
Thanks. I'll also quickly just share with everyone, the thoughts that Atul had shared with me. I had also asked him what are his thoughts about how royalty payments are working since the 2012 amendments, and his view is also that copyright societies are unable to collect monies, and then even payment from copyright societies to the artists or sorry, the owners of underlying works is not happening efficiently. So with that, maybe we'll move on to the concept of copyright societies. So Pragyan, if you want to maybe quickly just tell us just the basics of copyright societies and some issues that are revolving around copyright societies that we are seeing these days.
I hope briefs that I might have are not taken away by answering this question, because again, there are very interesting and live issues. But I'll lay down the areas and I'll not answer or give an opinion as far as my interpretation is concerned about these issues or what the law should be. That's for the courts to decide. Now, so basic thing is what is a copyright society and what is its purpose or object? And what are the issues arising out of a copyright society? These are the two things that I see as far as a copyright society is concerned. Now, the first aspect is, what is a copyright society? The Act says under 2 FFD that copyright society is a society registered under the Section 33 of the Act. Now, the intent of why a copyright society is there is found in subclause 3. Now, there are three stakeholders here. Okay, for an exploitation. First is the authors and the owners of copyright. That is one stakeholder. Second, for utilization, is the persons using it. They are the second stakeholders. Okay. Then there is a third stakeholder, which is basically the person intending to take licenses. So that is the third. Just 1 second. Yeah. So therefore that is what it is. Then you have something that is called. So therefore the intent and purpose of section subclause 3 was to protect the interest of the persons, authors and composers, as also the person seeking license. I'll give you an example. Now there are various authors and composers and music companies. Now, is it possible for individual music companies, especially the smaller music companies, to ensure that they are getting the royalty for the exploitation of their rights? I'm not talking of the big players like Sony and other players, but take cases of smaller players like Aditya Music, or smaller players like like Gitanjali and all of those. Now, it is not possible for them to have a team of people to go and see as to where all the music is being exploited, etc. So a copyright society takes over as a collective organization to ensure that the rights of these people, of these smaller music companies, like, and also the bigger music companies, are protected and they have more bargaining power as a whole, rather than trying and going ahead and issuing licenses individually. On the other hand, the persons utilizing it also gets a one-stop kind of a stop. So, for example, say you want to have an event in this, a seminar or whatever, but this is under the exemption. Suppose this was a commercial program and you wanted to play some music here. So obviously you have to have licenses. So you can't go to 100 different music companies and take licenses from each of them. So here was one body that you have to go to and take licenses. So the interesting part, however, as to what it does is a copyright society brings in transparency also, because you have provisions in the act as well as in the rules which mandates a copyright society to have a tariff, and that tariff has to be published. Not only does it have to be published, but it has to be also presented to the copyright registrar, right? So there is complete transparency as far as the tariff is concerned. So people taking a license knows that if I want a license, these are the kind of fees that I have to pay. I'm not getting into nitty-gritties of the discounts, etc. here that Pooja will explain, hopefully, on a non-official format. But that is what it is. That is what the law entails. But one interesting aspect, and that is an aspect which I feel will be a matter of litigation soon, and we'll all be holding briefs as far as that is concerned, is if you see, or if you pull out section 33, the act says that there shall be only technically one copyright society for one class of work. And anybody which is into the business, it says the act or the section starts with, no person or association can conduct the business of issuing licenses other than through a copyright society. It definitely has a proviso which says the music company or the company on its own can issue a license. But can a person who's into the business of issuing licenses can do so without being a copyright society? That's a major question that is going to come up, especially because when you have different people that you have to, for example, a person wants to utilize the music today. Does he go to one? He doesn't. He has to go to PPL, he has to go to Novex, he has to go to 10 other people. Is that the intent of the act? I ask myself that question, especially in view of the non-obstante clause that section 33(1) starts with. Beholds the proviso. The proviso probably contemplates a person like Sony to issue a license on its own. But can that right be given or assigned to a company which is exclusively in the business of licensing? Will it not be contrary to the main provision? So these are the issues that are going to come up, and hopefully it does for lawyers like us. So interesting issues there.
Right, thanks. Pooja, coming on this point itself, I wanted to ask you, do you feel copyright societies today are, efficiently doing what they're supposed to do, or do you think some reforms are needed in respect to copyright society?
Yeah, so I think the copyright societies are definitely making a lot of effort to, work their thing. But like how Pragyan said, that it's a little tough for them because this registration is one of the issues. That I think the multiplicity of societies is another issue. Also, I think the concern is more so for such societies is, if you see the DSPs today, they're not providing excellent reporting. If they did provide it, then societies could easily report back to the authors stuff which they need to. So that aspect hasn't been kind of factored in, though of course we are referring to a single society for single class of work. Overseas, again, I mean, I'm just expanding. Overseas, there may be multiple societies for similar class of work, but that leads to a lot of competitive rates when they're pitching for rates, when another broadcaster or a television division or anybody, goes and seeks out rates. I think that leads to a lot of competition vis-a-vis that. But from that aspect, I think in today's day and age, the societies are definitely making a lot of effort. Yes, we have a lot of challenges because in India also per se people are of the concept that you can use music for free. You know that, right? So I don't think that that's easy for even societies to deal with. And that's why they have to have legs, despite the fact that they could have just digitally captured it, but they still need legs on ground at different locations. So I think that is a very difficult thing. I think that primarily is the bigger concern. More than that, I think is the concept that most production houses or labels and things like that are not able to provide sufficient data appropriately to the societies. So I think the societies find it difficult to manage and provide all the data out. I think those are concerns. And obviously reporting is a very big concern. I think these are the issues.
So do you think some sort of procedure should be set through which, say revenues, etc., or reports of exploitation can be provided to copyright societies?
Yes, definitely. I totally agree with you. There should be a procedure. Maybe there should be just one place where everyone can go. Even if there are multiple societies, there could be just one site where everyone can visit and go and select from whichever society they require whatever licenses. That would be a much simpler process.
That's right. Actually, we do, because we get this question so many times as to, okay, we're doing this and what all licenses and from whom do we need licenses? So yeah, that actually makes a lot of sense if it's all in one place and who owns what and
Correct. It's not like we're asking to reduce the rates.
Yeah.
Everyone will have the same rate pitching, but it's just easier for public.
Right. Okay, I'll move on to the next question. And Pragyan, this is for you. You've already briefly spoken about the decision of Justice Endlaw, wherein the judgment states that there's no need to pay separate royalties for underlying works. If you could just maybe spend another 2-3 minutes on this decision and what is your view? Obviously, it's an appeal right now, but what does this mean for the industry?
Yeah, so first of all, I need to tell everybody that this judgment of Justice Endlaw is stayed now. It is no longer a good law as such, and as I told you, it's in appeal. And I've already explained my view qua that is that in my view that I think the Indian jurisprudence entails, if you read the act as well as the rules in a harmonious manner, I feel that the underlying works, which is there, the musical and literary works and the sound recording, entails two different licensing. And we realize this actually while dealing with a case with regard to section 31D. So since you have the rules, just see the rules regarding section 31D. I think if you see 30, I think, if I'm not wrong, I had done this matter a long time back. So if you just pull out 30, I think that makes it quite clear.
29 rule.
Yeah, 31, sorry. If you pull out 31, and if you pull out 31.5, that seems to be definitely the intent of the government. The board shall, within a period of 2 months from the last date of receipt of suggestions, determine separate rate of royalty to be paid to the owners of literary or musical work and sound recording. Okay, so what this entails is that two separate licenses are required and royalties, two separate set of royalties are to be paid. One to the sound record, to the literary and musical work and to sound recording. So therefore, two licenses, two sets of royalties. So I think that's the intention of the government. Now, whether with an interpretation of the other provisions of the Act, you can have a reading of that, that's a matter of debate and argument. But on a personal basis, I think that is the intent of the legislature. Whether it has been made very clear or not, that's another issue at all, completely. But this is my personal view on a harmonious reading of the complete Act. And I'm open to questions from Gauri to answer this.
I think what maybe Pragyan needs to cover up is also that example, if you assume literary work is an independent work, some musical work is an independent work, the rates can definitely be fixed for them separately, depending on how will they actually be used in a radio and television platform.
Correct.
That's what's important to be considered. Very less likely that literary work are going to be spoken in today's day and age, though that does happen, or musical work is just going to be played as an instrumental music. But in the television medium, less likely to happen. So when you actually have a radio and television 31D section, I think that's one of the reasons why. It depends on the other vision of will that ever be the case, or will it ever be separate from the sound recording, or will it actually ever be separate from a cinematograph film? The 31D doesn't apply to cinematograph film, it's restricted to sound recordings, literary and musical. But conceptually,
Yeah, sorry.
Go ahead, Pragya. That's it.
Yeah. So Pooja is absolutely right. And in fact, that's exactly the challenge, because the IPAB gave two different sets of royalties for two different sets. The broadcasting companies have filed an appeal against this particular aspect on these grounds, that you cannot have two licenses. And that's again, as Pooja said, it's a live issue. And again, whether this particular provision is only for instrumental music, which doesn't actually have a, the film music, etc. Those are issues that are to be interpreted and debated in court.
So just one more question, and maybe both of you can give your thoughts on this. With the abolishment of the IPAB now under Section 31D and other sections under the Act, the royalty fixation, this issue will go to courts now, to the various high courts. What is your view on this, Pragyan? And then maybe Pooja, you can also step in.
I think it's see, I have been principally always very against this tribunalization of various things. I am completely against that. I mean, you started off with CAT, Central Administrative Tribunals, and you had the L. Chandra Kumar judgment, which actually upheld something like that. But the tribunals have come in only because the government wanted to take control over the courts. And I principally have never been in favor of that. And what now the government, the present regime is trying to do is either merge a lot of different tribunals and court tribunals into one particular forum, or various jurisdictions have been given to the courts. So I definitely feel today, especially if you take Delhi High Court, we have one of the best commercial courts or the best IP sections today. And we have phenomenal judges. So I don't see any reason as to why the courts should not be a better option. Because as far as the Delhi IPAB is concerned, it still had technical people, although and technical people would be, some of the technical members would have knowledge of issues emanating out of the Copyright Act, but some might not. Some might be just an IS officer. But these Copyright Act and interpretation of the act is at its infancy today. It's a developing act, as you all know. It's a Cinderella legislation which is now growing into one of the showstoppers, as I can call it today, because there's a lot of action happening as far as copyright law is developing. So at this stage, I think this is a very welcome move by the government, okay, to take IPAB out and leave the interpretation of the statute to the courts, because there's a lot of issues of interpretation which are involved today. And maybe once the law settles down, maybe for the issues as far as determination of royalty, you can have a specialized tribunal or an authority. But as far as the interpretation is concerned, I think that should definitely be with the courts.
Pooja, any thoughts on this?
Yeah, so no, I was just thinking he's absolutely right in the sense that we need to have some smaller body or any other body specifically focused on ensuring that the rates are fixed in. Also, the rate process is very complex. So I don't think the courts would have that much time to delve into all of that and to give those rates. And also the manner and methodology is very difficult. Like even in the last case, 31D, everybody arrived at an in rem rate, which ideally is unfair to all the authors as well as the work in concern, primarily because it's unique. Everything is different. Artistic value is different. So you cannot actually peg it at a certain rate and blanket it across. So I guess from that reason, yes, you do require someone, but yes, to debate it out, like you're saying. But I also feel that if you miss this stage, you miss an appeal, like I was just mentioning to Gauri, in the sense that ideally from there, the appeal goes to the High Court, and then from High Court, it goes again, maybe further. But here, if you're already there, then how will the process be? I'm sure it'll be complex, but that's what I feel. We do need that. Thank you.
Thanks. Maybe we'll do one more question for both of you and then open for question and answers. Pooja, one question for you, and actually you did briefly touch upon this, but today we're seeing so many remixes. Literally every song there is a remix. What are the various rights that are involved? You know, if someone wants to make a remix today, is it clear as to what do you need to do, who do you need to approach, and do performers have any say when it comes to, say, a remix of the song? Because we saw a recent controversy where the remix was made and certain people were not happy with the way the remix was made. So what are your thoughts about that?
So where artists are concerned, obviously the ones who's created the original work, they're entitled to their moral rights. How the interpretation happens of Section 57 is to the artist, frankly. So keeping that aside, I suppose, maybe if remixes are there and someone else wants to make it, you break it up into cover versions. Primary cover versions will fall under 31C. That process, as I mentioned to you earlier, is complex. We can't deal with it. We can't make it unless the artist themselves or somebody sings it. The other issue is, as far as the remix per se concept is concerned, I guess the forums or platforms like YouTube and etc. have made provisions in their forms where they can cover disclaimers to enable people to actually allow them to make remixes and disclose what kind of remix or usage you're doing of a past license, of a limited license. In fact, they're making available certain kind of licenses online for you to make it, provided you give them appropriate credits for it. Of course, the fact still boils down to the fact is what is the de minimis use. I think Anil touched slightly upon it, and what would be what is allowed as the limited use of the copyright, and it is without the actual copyright infringement, conceptually. So that is something where I think is the concern, primarily where most persons who are making versions of people using TikTok and all the other mediums arrive at. And I guess that is very detailed. One, I think we had a Yashra judgment in 2012, which kind of detailed in exactly what those rights would flow, which I think have been reiterated again in another super cassette judgment recently in 19. But per se, there's the Berne and TRIPS conventions, which are very clear that there should be, and I would just like to highlight that there should be a special case why you want to make a recording. You should not exploit the original work. And primarily, it should not be prejudicial to the person who's actually, whose work it was initially. Obviously, that is primarily, right? You wouldn't want to hurt the person who created his work and would not want to diminish the value of his work. Of course, there are detailed 4 factors which have been set out, which I think everyone must be familiar with already. If it is work like we have under our section earlier, 52, if it's fair use, it's used for educational purposes, etc., then obviously it's allowed. So it depends on the nature of the copyrighted work that you're using. And obviously it depends on the quantum of the work, the heart that work is used for, what does it create, how much violation that happens, right? And the overall effect, in the sense, if that work, if it's a parody, how negatively is it going to be affecting somebody else? Or how does those rights affect someone else's monetization of their original work? I think there are many factors which are looked into at court to really realize what a fair use is. And hence, I guess this is a very debatable issue. It tends to go to court if an issue does arise, because you can't really debate or judge on your own whether, this has been, or these 4 or 5 factors have been captured appropriately. So primarily that's where it is.
Thanks for that. Pragyan, my last question for you, and we did briefly discuss this, and about, a lot of businesses, music is being used almost by everyone, say for business events and parties within the premises, etc. A lot of times people are not aware of the types of licenses you need, types of permissions you need. And one thing that we did discuss is maybe have one forum, one website, or a place where all these rights are whatever permissions are needed, whoever needs to give the permissions, it's all listed, right? Any other ways in which you think there can be more awareness can be raised about who to reach out to when you're using certain music, what are the exceptions, etc.
Yeah. So of course, I mean, any kind of awareness is definitely welcome. For example, take the case of today's seminar or workshop. So this is again another step towards bringing in awareness amongst the various stakeholders and the students who will then pass it on to others. They will become consultants to various or advocates to various, exploiters, person who is exploiting our music companies. So this is a form of awareness, and big companies like, I mean, Pooja's company should sponsor events like this. So definitely, why not? So that brings in a lot of awareness. So next time, the MNLU should have sponsorship from all the music companies, taking it forward and bringing awareness. Having said that, licensing is a matter of law, and ignorance of law, as we all know, is no excuse. And let me tell you today, obviously the broadcasting companies have deep pockets and they have a huge plethora of lawyers advising them. So I don't think that there is any lack of awareness as far as the broadcasting companies per se are concerned. The other persons exploiting are the various restaurants and hotels, etc. There, I understand some kind of ambiguity, etc. But they have the various federations like FHRI, NHAI. So these associations are there, and these associations have various lawyers. And I know it from a matter of fact that these associations have got legal advices, and these legal advices have been sent to all their members. So I don't think there is any lack of awareness in terms of the people exploiting it. The only problem is the intent. It is not about awareness at all. So the intent, as and Pooja rightly said, you feel that copyright is something which is, I mean, it's a free lunch. That mentality has to change, and the awareness has to be brought in towards that, rather than in terms of the fact that you need to have a license. So that is the awareness I think that should come in the market, and that's where, I mean, I think all of y'all and companies like Sony, Universal, etc., and all the music companies and the others should push towards, the awareness towards the fact that you have to pay for copyright.
Thank you. I think now we'll open the floor for questions. Yes, please go ahead.
So my name is Vinod. I'm a fourth year student at MNLU Mumbai, and I have a question. So we were talking about underlying work. So in a musical composition, generally, like from what I have learned, I know that a sound music composer gets the right, but there are various other people like a sound engineer or a mixer. So what is the status of copyright for those people? Is any protection afforded to them in Indian law?
So I think the performer definition is quite wide, and I think they're covering all of them actually in it. It's different that at times all that work tends to become work for hire because the performer work is still assignable, you see. So all the performers can assign all their work, including the current performers, and so also the authors. So assignability is not an issue. Performers are entitled to royalty. Those now the position would be whether they set up their own separate society like singers have, or are they part of the singer society itself? And if they are part of the singer societies, then they would be accordingly remunerated. That's how.
I think the question was with regard to composition or composers as such, and the sound engineers that are there involved with the composer while creating the music. So my answer to the question would be a clear no. The sound engineers and the other people who assist the composer in law have no right to royalty. It is the composer who has the right as an author, or rather, if I say right, the right to receive royalty. He is not an owner. So the right of the sound engineer and the other people who also contribute to the composition, the Act doesn't recognize that. The creativity or the creator of the composition is the composer only. This is what the Act entails here.
The one who gets the final credit. That is what I think Pragyan is referring to. What also does happen is that sound recording engineers and etc. tend to enter into separate agreements wherein they get separate royalties for their separate work.
Thank you.
Hi, my name is Murli Narasimhan. I have got this question both for Pragyan and for you, Pooja. There was a mention about IPRS. So, as a consumer, let me talk from the other side. So, I run a musical enterprise, and during COVID, we made an attempt to get a musical contest running online so as to keep the spirit and morale up of all the kids in the country who were confined to their homes. And it was during that, and the point that Pragyan mentioned about saying that it's not the question of awareness, but it's a question of intent. So we were aware that there is a law which says that you cannot use music, and we were already aware of laws of IPRS and music in auditoriums or halls like these or whatever. But there was no clarity about music in the internet space, in social media. And it was my attempt and multiple months of follow-up with IPRS and asking them questions on what is the kind of licenses that I need to take so that I can do this contest online. Because for any parent or a child, if it's a musical contest in an auditorium or a school or hall, there is an X number of audience. But what happens online? So online, if there has to be visibility, it has to be on the social media. So what kind of tariff is there for an online publishing of a contest and all that? Multiple months of follow-up and still they had no answers. And at the end of it, there was just one plain statement given to me saying that we don't have clarity, so go ahead and do what you want. Now, I'm saying that we are in this age. So it's not a question per se. I'm just giving you a perspective of saying how societies need to evolve. If we are in this age and internet is raging from so many years now, and we are all aware of the impact of social media and all of this, why aren't the societies are also keeping up pace with this kind of developments and getting the rules and regulations and acts much faster so as to help people who are already aware? So we are law abiding. We want to ensure that the law is, it's followed up and all the copyright royalties are given to the right kind of people, and we want to encourage the copyright societies. But they are not keeping up pace with the kind of requirements of the society. I'm sorry, I have an add-on question also. Extremely interested to know about anything about the Kantara Taigudam Bridge controversy, if anything on that can also be, given as an answer. So I've got two questions. One on the IPRS, it's more of perspective, and second is about Kantara, if you can elaborate on that.
I'm not aware of the second part of the question. I'm sorry, if Pooja is aware, she can answer. But coming to the first question, I personally feel that IPRS as an organization has always been very flexible in terms of issues that are, I represented IPRS for some time, so I can say that. In terms of issues where public interest is involved, or for example, you mentioned that you wanted to do the event for a public cause without there being any commercial angle to that, or just to keep the kids busy. IPRS, as a matter of fact, gives issues licenses in such situations completely free of cost. And there is an exemption that is carved out for these as far as the process is concerned. But I completely agree. See, the whole Copyright Act and the industry is, even today, after almost about 14, 15 years, it's still probably at an infancy. Okay, it's still developing. So there is a lot of lack of clarity as far as the newer areas of, exploitation is concerned. For example, say metaverse or things like that. So definitely, you are absolutely right when you say that societies should catch up. I have no doubt that IPRS and other societies would definitely catch up, and they should have processes in place to get anything to keep pace with technology. Absolutely, I completely agree to that extent.
So yeah, I think the whole reason would be because, again, touching the first point, I'm also not really clear about the other issue. But touching on the first point, what usually happens is that most of the distribution platforms or the social media platforms tend to take a license directly from IPRS. And as a consequence of which, whatever content you place on their platforms is already covered under those licenses, and hence you're able to enter into the thing and provide that stuff. However, if you're having a live event and it's a concert and there's a synchronization angle in it, then there's a separate license for synchronization that gets attracted, for which you would have to take a license from the respective labels whose content you're using on each case-to-case basis, which could be hard work, but that's the way it would be. So that's what that is as far as that's concerned. Yeah, sure.
Check. Hi. Hi, my name is Mandar Deshpande. I'm from Whistling Woods. So we, as academics, it's a very gray area that we play music for musicians in their academics for free. And then we'd ask them to charge for it. So it's like a huge contradiction happening there as well, because there is no clarity in context with what is free for education and what is not free. My question to you is, there is this new trend which we have been seeing as filmmaking institute, that many of them, they don't own the actual song, right? But they will ask someone else to produce the cover of the song and then use the or remix the cover version. How do you see this legally? Like, is it like allowed, or what is the thing here?
So your question is a little complex in the sense, is it a cover version that is playing, or is it just musical beds that are playing and which are new versions that were created and other musicians are lifting that and creating their full songs?
Yes.
Is that what you meant, right?
Yeah.
So obviously appropriate license is required for that embedded music, which is just underlying. And there are separate rules of licensing, which tend to be written very small. So you can't really read them, but they're there. So you have to take that appropriate license from those people before you actually use such content. So example, if there's a production house and there are big singers, they tend to use musical instruments which have actually embedded music lying in that, and they don't tend to take the license. Then ultimately, when I'm exploiting the content, that particular embedded music person can get up and say there's a violation. So yes, that is a concern.
Okay. The other part is when record labels are asking for, oh, you produce a video, and if you want like certain number of views or likes, especially with online streaming, your rights is mine. Like that kind of a contract is been seen with some of our students. So is it really possible for a label to own the whole right of the song, or the right is still with the author?
So section 17 clearly says who the author will always be, but their work is definitely fully assignable. So definitely it stands assigned if it is entered into a contract. Nobody can take away the rights of an author to be an author, right? So you have to recognize the fact that they're the authors, so they'll stay the authors.
Okay, thank you.
Okay, if there's no further questions, maybe we'll end the session here. My only last thing I want to say is, unlike the speakers here, the law is not black and white, it's gray. So thanks everyone. Just wanted to wake everyone up because this was an intense session. We'll break for tea, I think now, and we'll come back by 4 p.m. Okay. Yeah,
Thanks,
go ahead.
Pooja.
Thank you, Pooja. Thank you. It was lovely.
Before we
Aparna, how do we get our saplings virtually?
MNLU to answer the question.
before we break, I would request Dr. Dhumane to felicitate Pooja. With this, we can formally conclude the session. We'll break for tea for some time. Please head to the end of the corridor towards the back side of the room. We'll be serving snacks and tea there. Thank you. And we'll start the third session after it. That's fine. Just keep it. Yes, keep pressing. I don't think.
Yeah.
Hello, Lohita. Are you able to hear me?
Yes, I can hear you. Hi.
Yeah. Hello.
I'm sorry, I have like this really bad throat. I just didn't want to risk it to come, but I would have loved to join on ground.
Definitely.
I think one of our speakers is looking for a link. I'll have to just send him link of the session. I think Brijesh wants it. I'll just kind of put
I've
that.
emailed him as well, but
I'll just copy the mail.
okay. I'll also share it.
Yeah, I've done it on the group.
Thank you for that.
So is this something that you all are intending to host annually? Because it's a great initiative.
No, this is for the first time which we are doing on this very subject. But yes, a lot of workshops, deliberations, they are a part of our routine. So on different topics, different subjects, it happens
Right.
all the time.
So I've put the link on the group.
Yeah. So what aspect would you be taking?
So see, I can pretty much answer most of the, the questions. Let me just look at what you've. I'm kind of. So just to give you a perspective, we are extensively working with the ministry also on addressing the various challenges in law in the digital age. So I can pretty much talk about certain aspects that need to change, from a law point of view. On the enforcement side, I think, I had worked with Brijesh on the Maharashtra Cyber Crime Unit, but he's the best person and the expert to talk about it. We can talk about what happens globally, what are the different industry coalitions, anything else. Yes, I would definitely want to comment, and thank you for raising that on the extension of copyright, the term of copyright.
No, I was actually thinking about limiting the term. But yes,
That's okay. We can have a debate. But tell me your thoughts on why you would like to limit. Because I think from an academic perspective, there's a business angle that is completely getting missed. Because I have been on 3 other forums where I think academics were present, and they're like, 60 is enough. What is your thought behind this?
the thought is that because when life is associated, life plus 60, so it becomes somehow unmanageable. So
By whom?
by the actual owners of the copyright or the authors.
नहीं आप assign कर सकते हो. And another thing, see, I'll tell you where this is coming from, and this is not. I completely understand there is this general misperception that producers are creating monopolies by copyright term. But today, if you want to put your work out, say in a country like the United Kingdom, right? Now, because you're restricted in your own country by 60 years, you will not get that complementary protection in another country. And we are today living in a world of Netflix where you can turn on your television and watch Korean, Spanish, Turkish, Hindi, Marathi, Telugu, right? So why would you want to curtail that opportunity? I mean, if I'm making sense, and I think that's where we are coming from and saying that extending this. Hi, Brijesh.
Hi, how are you?
Tired. Not
Hello,
too.
hello, Brijesh.
हम लोग का दोनों का हालत है
Hi,
कुछ
hi,
ऐसी
how
है.
are you? And I have much more travel lined up here, I will say.
Yeah.
And I'm somebody who doesn't like traveling. So
Oh, I didn't know this.
I don't like traveling. I hate airports, I hate traveling.
And you can't do all your other events virtually?
नहीं, गवर्नमेंट टाइप तो जाना पड़ता है ना. Government doesn't work digitally, Baba.
So are you involved in any aspect of, cyber? Of course you are, right? In a lot.
No, not formally. I'm not handling that charge in that sense. कितना time है इनका भी?
I think I put it on the group. It's like 4. I think should we just connect back at 4? Should we
Think
just
so.
log in? Hello?
Surely, surely.
Should we just connect back at 4?
Yes, fine. So, why I said like, please join early, only to just say that if technically
Yes.
everything is all right. So it seems all right. So definitely at 4 we can join and let's see how it goes. So.
Surely.
Yeah, I'm sure it'll go well. We have a firecracker who just logged in, so it'll be very good.
Who's that?
You.
Of
Hey,
course, you.
Baba. Bye.
Bye.
Thank you.
Okay, welcome. हे कोणाचं ते घेऊनच नाही घेऊ
Thank you so much.
एवढ्या बाटल्या बसून
infringement and enforcement challenges. The media and broadcasting industry is growing rapidly and traversing its own traditional models towards newer pastures. Naturally, new challenges are emerging with such growth. Where the phenomena of internet piracy has grown manifold in the recent times, some contributing factors may be in the absence of limits as to the number of people that a material can be distributed to, ease in distribution of material through the internet, and the difficulty in distinguishing between fake and original works. Two fundamental questions posed in this relation to any IPR administrator are what to administer and how to administer. To further elaborate on these pertinent questions and to discuss today's theme, we have on the panel today Mr. Brijesh Singh. Sir is the Additional Director General for Police in Maharashtra, formerly responsible for Maharashtra Cyber, a unit looking after the cyber security of the Government of Maharashtra. We also have the pleasure of joining us virtually Mrs. Lohita Steve. Ma'am is the Senior Director, Copyright and Digital Economy at Motion Pictures Association, India Office. Next, we have on the panel Shinoy Prasad, Practicing Counsel at the High Court of Bombay. We are deeply honored to have a panel of revered and esteemed dignitaries amongst us today. I now hand over the platform to Professor Sajid Sheikh, Assistant Registrar Academy, MNLU Mumbai, to kindly lead the discussion forward and engage with our esteemed resource persons today. Over to you, sir.
A very good evening to all the esteemed speakers who are present offline as well as online. This is the gift of pandemic that nowadays, like, we are exploring these hybrid models as well, and the distance is limited in this very manner. So this is the third and the last session for the day, and a very important session. It's on copyright infringement and enforcement challenges. And we have esteemed speakers, one from the enforcement wing, Mr. Brijesh, and another from the production house, Ms. Lohita, and practicing advocate as Advocate Shinoy Prasad. We know that, yes, for enforcement and to detect infringement, law exists. There are civil remedies as well as criminal remedies available in the law. In civil remedies, of course, injunctions are there. Marwa injunctions, Anton Killer orders, John Doe orders are passed. In the cease and desist orders are there. And in criminal remedies, punishment from 6 months up to 3 years is there. And of course, fine is also there, which goes above 50,000 to 1 lakh rupees. And of course, in multiple offenses, the fine increases there also. So, of course, considering the kind of audience we have in India, not specifically you, I am saying the users, the Indian users, due to lack of awareness, sometimes infringement becomes hyper-normalized. We think it's okay. Whenever we search online any music, we'll get like the pirated sites offering music content to be downloaded as on the first search page. So maybe we can have opening remarks on this very question itself. Is IP infringement so hyper normalized? Maybe we can start with the views of Mr. Brijesh, and then we'll go to the specific questions. Mr. Brijesh, over to you.
In fact, you've hit the nail on the head that though we should take IP infringement equivalent to theft, we do not. So somewhere there is an implicit lack of public support for these issues. And the normalization is such that people believe it's nothing wrong to use pirated content, download, transmit, upload. And I would say that there are various kinds of issues around this, that there is a whole mechanism, a whole, technological environment which enables this. For example, Google has a Lumen database, which basically delists things from search, but that is only after effort, that only when you sort of complain, then effort is taken to bring it down, bring such infringing content down. Similarly, all other such platforms, there are, various degrees of enforcement, automated enforcement, I should say, which leads to a clear availability of pirated material. Now, if something is illegal offline, that is illegal online. And in this, you should see that these platforms, be it messengers, be it social media platforms, be it search engines, everybody is in clear violation of law. And I understand that the volume of such material is very high, but technology has made it very simple, cheap, and ubiquitous to simply, copy multimedia from somewhere, change its format, upload it anywhere, distribute it to a large number of people, hence normalizing this. And apart from this, there is a slight technical difficulty in actually assessing the extent of damage. Like, so let's say one pirated movie seen by somebody, is it equivalent to one movie ticket lost? Or are we looking at, let us say a number of people not seeing a movie, seeing it on the device, then in that case, taxes lost to the government, employment lost to the people for whom work would have been created, so on and so forth, the larger implications of this. Plus, where is this money going? This is going towards the enabling of this ecosystem. So there's a whole ecosystem which has normalized this, and it's not just the individual behavior. I feel that somewhere these platforms should also be held responsible.
Rightly said, Mr. Brijesh. But again, talking about the mindset of the user. So I want to pose this question to Lohita Sujit. Is the Indian mindset or general mindset of the people also responsible that they do not take infringement seriously?
So, in many territories like Australia, for example, the general mindset, when it comes to piracy is that, okay, you can't afford a particular kind of content. And there was a study done on user habits in Australia, and they found that the higher the income, they actually pirated more. So I don't think, from a user perspective, it's a mindset. I think we really need more deterring laws, really more action, and to what, Brijesh said earlier, in today's date, we all know that if I have to, approach a service provider, that service provider gets 36 hours, to take down my content subject to a court order, which has to be produced in 21 days. So there isn't enough deterrent. Recently, we saw that the Supreme Court has, said that the copyright infringement is a cognizable offense. I don't know if the penal provisions you mentioned earlier are deterrent enough. So, I think more than the mindset of people, I think there's a lot of effort from the government to have outreach programs, and there's IP training even at the police level now. But I think we just need more deterring laws.
Rightly said, ma'am. Thank you. My connecting question is to Advocate Shenoy. So, does our law have enough space to allow infringement, rampant infringement due to maybe incomplete definitions of something like fair use, which allows infringement to happen.
So in that sense, fair use is a defense tool. Yeah. So there is no so in that sense, it may not be in that what do you call it, area of concern for particularly the people, right holders in that sense. But from the perspective of a right holder, you're looking at primarily three kinds of infringement. One is the inadvertent infringement. For example, if I go onto YouTube and I view a clip of a 1 minute clip of a movie which has a, let's say, a funny scene, or let's say a Batman movie, and that is still copyright infringement. It's not something that should be reproduced. It should not be something that is viewed. But I'm sure Warner Brothers has bigger fish to fry than go and see this 1 minute person who's viewing these videos every minute or every second. But there are two other concerns that the bigger players or the right holders may have, even in that sense, everyday right holders. And they are to do with the kind of people who are producing the copyrighted work, reproducing the copyrighted work illegally and sharing it. So these people are the ones that when you talk about normalizing copyright infringement, this is the biggest concern I feel for the industry, because the third, of course, copyright infringement is by end users. That is people who go on to, let's say, websites like Pirate Bay, download movies or copyrighted content in order to view it, because either one, it is content which they cannot afford or don't want to afford. That is, they think that they should not be paying for it for whatever reason it is, or they can't pay for it. And the second part is that for people who, in that sense, own these websites. Like, for example, a good example of it would be something like Popcorn Time. So you see, the thing is that as far as the first person is concerned, we hardly see any action from copyright users in court, copyright holders in court. We mostly see action from the second or third perspective, where you have people who are sharing these, who are actively sharing the copyrighted work and enabling infringement of copyright, or the third one, which is where people are using copyrighted work. I feel as far as the second is concerned, there is a lot of litigation that goes into it, a lot of investment that goes into it, because, right, like, for example, between 1999 and 2015, the US, I think the copyright industry saw almost saw a reduction of almost half the revenue due to copyright infringement, and that's some serious amount of money that is going down the drain for right holders. But there has been a reversal since then, and the reversal has nothing to do with stricter copyright laws. There are enough copyright laws that are already in place, and I feel that there are enough copyright. Of course, there is always a great deal of scope for clarity, even in India or for that matter outside. But as far as enforcement of copyright is concerned, the question is, are you willing to put in that much money into stopping someone in one corner of the world to stop watching your movie? It does not make economic sense for a right holder to go after one single person doing something in one corner of the world. So what you need more of is, as far as the end user is concerned, because I guess I'll come back to how the industry can deal with the second kind of infringement, that is a sharing kind of investment, that is people who generate and enable copyright infringement. But as far as the third part is concerned, a great amount of copyright infringement has been reduced by making legal content available online. For example, platforms like Netflix, Spotify, platforms like Prime Video, and all these OTT platforms have led to, at least, I mean, I don't have the data for India, but it seems like in the US, the amount of copyright infringement that is occurring from people enabling sharing of, I would rather go to Netflix and watch a movie than go to Pirate Bay and download something and then make it available and then put it on a computer and then again order it on my television. So it's just a big amount of, you're highly disincentivizing the end user from normalizing infringement of copyright. The moment you start doing that, you start checking your copyright right there. When you say copyright infringement is normalized, I think the best way to go about it to change that normalization is by making it inconvenient for it to be normal. So that is, I feel, much better than having any kind of enforcement rights, because enforcement costs money. And I don't think anybody here is willing to bear that cost. Not the ISPs, not the government, not the police, not anyone else. The people who have to bear it is the right holders. And the right holders really don't want to spend money on litigation. What they want to spend money on is making better content.
I want to quickly come in and make a few points. I think at least the right holders that we represent, and we also support several other small production houses because of the services my studios offer. We are consistently filing side blocking actions in the Delhi High Court, and it's been a very progressive court for us. Brijesh, I would request Brijesh to talk about it, but there are arrangements where copyright holders work with the law enforcement for action. Internationally, the advertising the advertising companies assist right holders in, stopping infringing action by blockage of ads, etc. So I mean, I will urge British to talk about the arrangement with right holders. And right holders do take our interests very seriously.
Yes. Hello. Yeah. Yeah. Thank you, ma'am, for this very point. But again, I'll come back to you again on this very question that yes, which Brijesh also raised, the due to availability, a lot of infringement is happening, and this was resonated by our chief guest in the morning also, Professor Tabriz Ahmed, that after this digital boom, massive infringement is happening on multiple platforms, which are beyond the control with respect to finding out when infringement is happening, where infringement is happening, maybe due to the reach and the servers, etc., are available all around the world. So from the production house side, how do you deal with this very issue of massive infringement, and whether from the production house aspect, whether some measures are being taken to control this?
I'll answer your question in two parts. Let's look at the law. When we are talking about normalization of infringing copyright, etc., we saw that just in the pandemic, the new normal, there was a loss of USD 2.8 billion, right? And therefore, the measures now have to extend to various parties in that ecosystem. So one recommendation that we have is to have know your business customer obligations within the law. Make it also, some kind of penal provision to look at infringing apps, because that's where the piracy spreads the most. And sometimes, honestly, consumers don't know what's an app, but the service providers that manage these app stores, right? They need to have some kind of a due diligence in place. Lastly, if you look at the technological protection measures in the Copyright Act, we don't have a clear definition for effective technological measures from an access control point of view. I mean, we do address it in courts through side blocking, but our law really is falling short in that regard. I think a couple of these things combined with, especially what I said earlier, the know your business customer provisions will help deter the problem in future. To your second question, from a production house point of view, we do have regular audits. So the service providers, say, for example, where the post-production work, etc., is conducted, there are regular audits done, and to a large extent, we don't find too many leaks happening at the source. And also, if you look at the camcording part of it, we are hopeful that the bill will pass, because that will have stringent anti-camcording provisions. And I think the government somewhere is also kind of looking at it from a view that everything need not be restricted to a cinema theater itself.
Right. Thank you for your views, ma'am. My question to Brijesh, now I'll come to him, is about how enforcement agencies are dealing with this issue of infringement, because we have seen recently a lot of ISP, with the help of ISP, they have been blocking a lot of this torrent sites and other sites wherein such excess of sharing this very media is allowed. So are they successful in that very thing of blocking that very access? Vijay sir, are you there?
Yeah, there's some slight network issue, it seems. So I'm hearing you in breaks.
Okay, so I wanted to know, like, what is the idea from the enforcement agency side, how they are dealing with the problem of infringement? Because law exists, though it appears that some void is there, but law actually exists, and so is law actually being enforced?
So many things. You know, though I share the enthusiasm with which Lohita is exhibiting, but there is also a lack of seriousness on the part of producers towards piracy. I have seen it many times where people are actually happy that their thing has gone viral, and they are not ready to commit resources to this. Apart from this, it requires a very large technological infrastructure because the volume of things out there is very large. So, to identify something like that, you have to run very detailed crawlers. Then, with these crawlers, you'll have to pass this data, find out, let's say, based on any metric, based on hash, based on content, you have to identify this material. Then, you have to confirm the legality about this material being pirated. If there is, let's say, a hidden watermark or any mark that you want to identify it for the purposes of evidence, then you have to find it out. All this is mostly multimedia. So look at the amount of data that you have to process, and this requires a huge technological infrastructure. Apart from that, it requires trained resources who deal with this kind of fragmentary evidence, with this kind of forensics. Then again, the difficulty of obtaining data from platforms. And nowadays, with anonymization, with encryption, with decentralized networks, I mean, Tor is a thing of past. Today, a lot of this infringement has shifted to real-time platforms like Telegram. Telegram can have supergroups of 10,000 people, and you can have a 2 GB file floating there within seconds with easy download access to everybody. And then you can have hidden groups where nobody has access to. So the difficulty of finding what is happening. See, Tor is slow. BitTorrents can be tracked if they are not private if they are not using private trackers. But something like Telegram, something like Discord, any such messengers, which are real-time messengers where there is no limitation on the file size, this is happening. And what will you block? What will you bring down, right? Because it's a totally P2P decentralized infrastructure. However, having said that, we actually did a very successful experiment. In fact, Lohita was a part of it. We started this unit called Maharashtra Cyber Digital Crime Unit, and it was recognized as one of the 6 significant units across the world by World Intellectual Property Organization. It also went on to win the US IP Champions Award by the US government. Now, what it could do in a short time was that it blocked traffic of the tune of 400 million hits per month, and it did something very interesting. So we didn't go for kind of legal measures of obtaining John Doe orders from court. We went for administrative blocking. Like, we approached the authority, and basic thing we started asking them for due diligence of these pirate sites. And interestingly, when we initially used to go in conferences, then all the foreign countries used to castigate us by saying that, oh, your performance is not proper, and so on and so forth. When I realized that only 14% piracy was emanating from India, 16% was coming from outside. So we concentrated on our 16%. We brought it down significantly, and then we went to them and we said, hey, how about Cloudflare? You don't give IP addresses, you don't give any this thing, you don't comply to any blocking requests, you don't. And after GDPR, things have become very difficult. That even if you try to get who is data of the host of where a particular thing is hosted, so you don't even get the domain name registrar, you don't get any of the registrant details because it is redacted under privacy laws. So it's fraught with difficulties. At every step there are difficulties. There are problems like jurisdictional arbitrage. So and then obtaining pertinent orders from such a plethora of courts which operate at a very different speed and very different understanding. Having so many resources to follow up one case. So it's very easy to make an IP infringement complaint. But imagine the kind of paperwork which goes into it. It's very disproportionate. And that is why the way we went about it was that we shared this responsibility. So service providers and law enforcement, we came together to create a public-private partnership. We said, hey, give us resources for this. Because, we can't be writing all these emails to everybody and then can't be tracking because there's so much of scriptry work. Apart from that, you have to track, the legal proceedings in each court, obtain evidence. And for each bit of evidence, there is a long procedure. So we took resources, we took specialists, we took even infrastructure, digital infrastructure, crawling infrastructure from the private sector, from, let's say, bodies like MPA, and we created this unit, which was a highly successful experiment. So I believe that it can be done. There are ways it can be done, but there has to be seriousness on all sides. While there are laws, we may talk about stringent and stricter penalties, but I will tell you something in reality, that the certainty of law is much more important than severity. That it maybe, let it be a small punishment, let it be a 2-month imprisonment. But if it is 100% going to happen, then piracy will stop. And somewhere there has to be an apportioning of responsibility on the enabling ecosystem. So one small thing, let me tell you, that we found that people were making money not by selling pirated content, but by putting it on sites which became so popular that ads would run on that. And you won't believe that very large banks and multinationals were running ads on that. So what we did, we went after the payment ecosystem. We found out where the payment is being obtained from. We issued notices we issued brand advisories to those people who were advertising. We cut the network of payment systems by telling them that, look, this is proceed of crime. You can't deal with it simply. So we went on to do with it. But this is whack-a-mole. As soon as you do something, another digital identity pops up. So it's a game of eternal vigilance, which requires large infrastructure, large digital infrastructure, which requires specialists, which requires a legal team, and it requires a lot of effort and also public support. So till we are lacking on all these points, I don't think so we can come up with an effective enforcement action.
Thank you. And sir, very well highlighted this very point that a joint effort is required from the, government side also, and from the, production houses and all. And therefore, in that very manner, we'll be able to curb this very problem. I want to know from Shinoy about how courts are reacting to infringement related matters.
So the courts are pretty proactive. You see something like John Doe, from John Doe orders to recently there was a action by Mr. Amitabh Bachchan where he wanted to in rem, in that sense, has been completely patent all his in that sense, or everything to do with his his voice and his mannerisms and all those things. So I mean, courts are always looking to widen the scope for right holders to enforce their remedies. There is no question about that. But again, we go back to the question, I think Mr. Brijesh Singh put it really well, that no matter how stringent your laws are, the question in the end remains whether they are worth enforcing or not. Because at some point of time, it's a question of, it's a pure commercial call, whether how much you want to pay or how much money you want to put into this in order to curb end user infringement. I feel you're much better off approaching courts to curtail source infringement, which is curtailing websites that, going to courts for like she said that Delhi High Courts are very proactive in giving you orders, and all of the ones that the orders she's been obtaining are orders against source infringement, which is where you have these sharing websites where you have these people who share this copyrighted material in order to enable people to infringe copyright. So that's one part of it. But I feel litigation in India is pretty, in that sense, is whatever said and done a little difficult. Like you do get ad interim orders, you do get interim orders, but final orders are very difficult. Your suit, you will never see the end of the day for your action. So there's so we can just look at what other countries are doing in this aspect. Something like the UK, they've got something called the, if I'm not mistaken, they've got the Digital Economy Act, which is similar to our IT Act, where there's a Ofcom, that's the Office for Communication. Now, interestingly, this was never implemented, but the mechanism that Ofcom provided for is to focus legal action on the most pertinent alleged infringers. So if you have a particular infringer, let's say the ISP knows that this website belongs to a certain IP. Okay, let us not look like, I mean, I understand, as Mr. Singh said, that obfuscation or obscuring of source is a challenge in itself, and I quite appreciate that. But apart from that, there is something called these in that sense a warning notice or something called a copyright infringement list they were proposing. Now we have that in India for a parallel, if we can think of, is something like the willful defaulters list, where you have people who have taken loans and who have not paid back for 1, 2, 3, 4, 5 reasons. There is a list of them, and no bank ever goes to them again. They will never have loans given to them. They will never have amounts paid to them. Now, what happens is that with most sharing websites, you will have to incur a certain amount of cost in order to ensure that you are able to host that kind of material, and you are able to also, in that sense, that make available for yourself that kind of internet services. So there is some amount of money that is in play here. If the ISPs, I understand that ISPs are highly touchy about making them liable for anything. But if the ISPs, there is some onus on the ISPs, or maybe a joint venture between ISPs and some kind of neutral ombudsman that helps identify who these infringers are, gives them, there's something called a 3-strike notice, which is used in France, where the first one is sent out with an educational perspective, where you educate the infringer saying that you're not supposed to do this, and this is a problem. The second one is a warning, and the third one tells you that your speeds are going to be curtailed for internet speeds, and internet use are going to be curtailed. The websites that you can use are curtailed, and all those things are put into force. So if you have that kind of a list where you curtail access for certain people for a limited period of time, in order so that they don't share such copyright infringement. Another point why this cannot be applicable for end user is because back in the day, you used to have a very clear dichotomy between infringement and non-infringement platforms. That is, if a movie is playing in the theater, that is not an infringing copy. If a movie is on the street being sold in a CD, that is an infringing copy. Today, if you curtail someone's, if you, let's say you think that there is this bunch of people in this institution that are using copyrighted material, you curtail the infringement of that, you curtail the internet speeds of that institution, you do not give them internet. You're also affecting parallelly legal ways in which they are using your material. For example, curtailing a person's internet will also mean he can't use Netflix or Prime and Spotify or whatever it is. So your problem is that the same road is being used for both purposes. And that is where your difficulty also comes in. And that's a difficulty which you will have to address. But apart from that, I still believe that enforcement of copyright against end users is just too wide. And I don't think that even if you are able to go to court and get orders against such end users, it becomes an unending, infinite task in which you are going to end up spending a lot of money, which is going to be, in that sense, it's just impossible to do. It's much better off to look at the source infringement part and try to curtail that with the help of ISPs and the government coming together in order to see to it that source infringement is curtailed. Once source infringement is curtailed, it becomes very difficult for end users to go and seek copyrighted material, which means that they will naturally, there'll be a behavioral shift to a more copyrighted, in that sense, use of more copyrighted material. And the last point I would like to make is that the use of, in that sense, legal services in order to enforce this. So if there are, for example, if there are mechanisms within, let's say, different IP law firms, which there are dedicated cells that are only doing this, your amount of specificity and the amount of the technical expertise increases, and that is the kind of investment that I feel a lot of these producers and the right holders should make in order to ensure that your copyrighted work is protected, than going to court every time and obtaining orders which you then have the headache of enforcing again. So that is just that's where I would conclude. Yeah.
May I make two quick observations on this?
Yes, yes.
One is that, as I think the earlier speaker only pointed out some time before, it's an economic question. So if you remember in the good old days of CD, Moser Baer came up with this cheap CD model, where it started directly competing with the pirate, and it made a good market. Similarly, if you look at the model of right from Spotify to Ghana to Apple Music, they are making music very cheap and affordable, which is actually creating a huge dent in the pirate ecosystem. As regards the economy of the pirate ecosystem, see, the money is still paid by advertisement. It doesn't come from piracy. It comes from the sheer virality of that site, and no site is as such sharing material today. So you cannot pinpoint the infringement and, let us say, get an order issued. Most of the infringement is happening on P2P networks, which are well-nigh impossible to block. Now, like, how do you block a private torrent? So you have no mechanism to block. Or in fact, if something is being shared on Telegram, or even you have things like Kodi boxes today, which are like a set-top box, which is connected to torrent behind, and then it uses Tor on top of that. So through Tor, it is having a streaming service through which you can access everything. Now, this is virtually impossible to detect. So technology is a moving cloud front, and technology can be fought with technology. And here it needs a huge investment. And I feel that industry, while it is wanting to preserve and protect its content, has to come and proactively invest in measures apart from, let's say, digitally watermarking it and things like that, in some kind of a threat hunting. It will have to invest in threat hunting and forensics and digital analytics for as a countermeasure to piracy.
Yes, thank you, Brijesh. Yes, technology has to be used in order to counter piracy. And since Lohita Sujit has already worked in this very area, has worked with government also, ma'am, I would like to know your views, like what is the role of technology in countering this infringement?
So I think Brijesh has covered, this in his, earlier points. I think it has to really come in from a form of investment by the industry. But I would like to highlight, one of the positive developments that happened during the pandemic. The US passed a law called the CASE Act. And that essentially is in the support of small creators. And they built this mechanism within the Copyright Office, where if you are a small creator and, to what Shinoy mentioned earlier, it's a cost, you can actually go and complain and you get a relief of up to, 30,000 US dollars, between 15,000. So I think introducing statutory damages in the law will really help, and I think academics should come together to get this instilled. Apart from that, everything else, that Brijesh said is true, and without investment in counter technology, it's going to be very difficult. But I will say that one of our studios took a very good action again with the help of the Maharashtra police in capturing the founder of Thop TV, which essentially is, you know, an app you can download and it will just create an interface where you can watch all your, you know, video on demand platforms free of cost. So that kind of action is always welcome, but it has to come from the industry.
Right. Thank you, ma'am. Again, ma'am, a question which I picked from what Brijesh was saying earlier. We see like the media houses selectively enforcing their rights sometimes. Maybe because of convenience, maybe because of the efforts and the money which is involved, and maybe sometimes because it is not worth litigating. So even in the cases where clearly corporate infringement is detected, so from the media house point, would you like to throw some light on it and whether we can change this very narrative?
So I won't be able to comment on other studios. Frankly, that's not my place. But I will say that the studios that we represent, because they're heavily invested in the Indian market, right? See, today when you're talking about creating content hub of the world, I think they are very serious about protecting what they create. Because today what you create in India can be viewed anywhere else in the world because of the sheer reach that your online streaming platforms are concerned. And I think I have not seen any such case, please, as far as my studios are concerned. I think local studios need to decide the value of their content. It definitely doesn't make sense. And, you know, like Brijesh said earlier, nobody's stopping them from coming together as a coalition, investing that kind of money and, you know, working with the police closely to get far more faster action than they would if they went to court. And I think the model that Brijesh, you know, led is proof to that.
Right. Thank you, ma'am. My question to you, Shinoy, is, you know, are the like corporate holders, and I'm not talking about the big creators here, normal creators, because now is the era of influencers, social media entrepreneurs. So are they vigilant about their rights, and are they effectively using the court mechanism to protect their IPs?
See, a lot of times what happens is that as far as these smaller users are concerned, a lot of the copyright fight is with the bigger copyright holders. For example, a smaller person who's like people who have written stories and questions of authorship come up, moral rights come up. Those a lot of these people, the biggest recourse they have is against bigger companies, production houses that, in that sense, you know, that do not want to share revenue with these people. And these people are in that sense very much protected by courts, because when they are in court, a lot of there's a lot of informal pressure from a judge that in that sense to, you know, in that if they are like let's say there's an author of a script who's come and said that my script was I had sent my script to a production house and the production house has produced a web series on it and I'm not being paid. That is the kind of I mean the only recourse that a scriptwriter has is to go to court and ask for an injunction against that production house, and those are given. But as far as the smaller holders are concerned, what happens is most times the smaller holders sell out to the bigger production houses. That is the only way they can put out their work in the bigger world. I mean, of course, now there is self-publication and you know, one-hit wonders and all those things, but and Instagram, of course, it's, you know, of late I've heard that, you know, a lot of production houses just recruit their artists from TikTok, where you're 60 or 70 of the top years like you know, users who get into the music industry. But you see, the moment they get into the music industry, those users are no longer concerned with their copyright as much as now the production houses, because now their money, now they've already been paid by the production houses, and now the production houses are the ones that need to enforce the copyright. So it still remains a question as to how much the production houses want to invest into copyright infringement and in courts. And I feel production houses are pretty proactive when it comes to infringement of their copyrights, or copyright is being enabled. The copyright infringement is being enabled. And I feel that courts are also very proactive. They've come up with quite a few mechanisms in order to help curb copyright infringement, there are newer and newer nuances. Like, for example, of course, it's been a while now, but John Doe is a very common example of something like that. And that really helps people, in that sense. You don't have to wait for an infringement, or you don't have to wait for a movie to be released and all those things. Nowadays, for every movie, a John Doe order is being taken like a week before the movie is released. So in that sense, yes, I feel that the courts are quite proactive and quite, in that sense, at least at the interim stage of providing immediate relief, courts are very much a go-to in the copyright industry.
Thank you for your views.
Sorry, there's just one more thing you had asked me about, and that was arbitration as far as copyright is concerned. So I
think of a speedy remedy.
Yes.
Yeah.
Yes. So I think more and more you see that copyright is becoming a question of licenses and agreements, of assignments and agreements. And the moment it becomes that, it is becoming arbitrable, of course. And when it becomes arbitrable, you're seeing very specialized arbitrators in the field of, if you have a bunch of IP specialized law firms, they're the ones who are in that sense, doing a lot of IP litigation and IP arbitration, and they're coming up with a very speedy remedy for, in that sense, even between intra-production houses. But again, it remains at a very macro level where you have, let's say, for example, a big production house suing another. I have never seen an arbitration where, you have copyright infringement. For example, Netflix is suing one of its users for copyright infringement or something like that, where it is actually it's actually possible for that to do, for a user to do that, to use Netflix in order to infringe the movie's copyright. But you see a lot of copyright, that level of copyright, either copyright action or copyright infringement is not being seen in courts, and not only ours, in any court for that matter.
Thank you, Shinoy, for your views. So we now will be concluding this very session. But again, one view was coming to my mind. Actually, not one view, two contradicting views, in fact. One view is that since copyright, the subject matter of copyright is evergreen. So is the period of copyright, that is life of the author plus 60 years, enough, or it should be extended? On the other hand, another counter view is that this life plus 60 years, it's too much. If you compare it with other IPs, it seems to be too much. So because of which, more infringement is likely to happen, because when something for so long is there, it is difficult to control. So I would like maybe we can have view of Lohita ma'am, and any concluding remarks. Yeah.
So, term of copyright or the life of copyright should be viewed from a creator's point of view, right? So if you look at any of the big franchisees that you see, most of them came from probably a comic book, and then, the IP really evolved over a period of time, right? And in most of these cases, for these brands to become really strong in terms of having theme parks or merchandising, it does take a lot of investment and time. That's the first thing. So I think anything which gives longer protection to a creator should be welcome. The second thing is, if you look at any of your, countries, whether it be the US or United Kingdom, I think on an average, 80 countries across the world support 70 years. If we do not want to support this as a country, they'll just not get that reciprocal, benefit when that content goes to the other country. So I don't know if that's a really good thing to happen. And there are enough commercial agreements that can be in place if anybody wants to use an IP today. I think non-exercising that is not really the creator's fault.
Right. Fine. Definitely, we should give more points to the creator so that they can exploit their creativity more. So last view from Brijesh. Since you talked about the model at Maharashtra level, this digital cybercrime unit is something on a national level or international level we thought of, wherein this joint partnership can be there in order to curb this very menace of infringement and effectuating the enforcement part?
I think the Maharashtra model is something which can be followed across the world because it basically created a collaborative model where you were enabling each other. So law enforcement, where it was lacking in strength and expertise, the industry was coming and providing, even intelligence. Industry where it was lacking enforcement teeth, law enforcement was providing it the enforcement teeth. Like a notice going out with the authority of law from a law enforcement agency which is investigating something. It also led to a kind of enhancement of knowledge on both sides. So let's say our investigatory practices were enhanced by knowledge from the user, and probably the industry also benefited with understanding how law enforcement functions and can function. Also, then the sheer question of who will finance it. So it created almost, I should say, a layer where industry was financing it not per case basis, but it created a common pool where anybody who's unprotected also can come and avail of these services, because we're very clear since the beginning that we cannot create a pay-per-use service because we are law enforcement. We will not be able to say no to anybody. So it created a nice model which showed that how industry and law enforcement can collaborate on strengths and then learn from each other. So it's a good model. However, across the world, if you really want to tackle the question of piracy, you'll have to come together with a slew of, awareness, technology, legal measures, plus, some very sincere effort and investment in this whole field. Thanks.
Thank you. One last view from Shinoy about whether there is a need of like an agency, just like we have of WIPO Arbitration Mediation Center, maybe some agency in India, wherein which can play the role of a mediator and settle the disputes, because not everyone can go for arbitration, not everyone will go for litigation. So what happens sometimes, they just let go. So whether some agency can be thought of.
I think it is quite a great suggestion. In fact, we have seen that with something like the NCLT, where you had the whole recovery mechanism now is very quick, and you have a bunch of people who are, in that sense, it's only the things that are not disputed. Those are the cases which are seeing very quick orders and quick recovery. But that said, there is a very clear incentive in the NCLT for banks and the government in order to establish that organization. The question is, does the present government, or in that sense, the present copyright holders, have the incentive to invest that kind of money into setting up a mechanism like that, both for investment and both for enforcement, that is obtaining orders, and for eventual eventual enforcement of copyright. I understand 100 crore loan wanting to be recovered. You're paying your lawyers; they're going there. You have a whole investment that the bankers are made, that the creditors are making in order to recover that money. But what if that is the kind of money you need to spend on making sure that you have, there are the lawyers engaged and that orders are obtained in that court. Whatever said and done today, you have to also balance it with the rights of the people who are using that copyright. There has to be an adjudication that there has been an infringement of copyright at some point, because you cannot enforce a right without adjudication. And if you are not going to, who's going to pay for this adjudication? The biggest problem that today we are seeing is that nobody is willing to shell out money. Everybody wants their rights enforced, but nobody is willing to shell out the money for it. And that is the long and short of it. Because in the end, as Brijesh said, there are so many mechanisms and so many ways of curtailing this. But beyond the point, it's the copyright industry's commercial call to take that if I want to stop copyright infringement to this extent, does it translate to money coming in for me? I understand the moral turpitude behind it of saying that nobody should infringe copyright, but in the end, it also ends up being a commercial balance. And that's a commercial balance which the copyright industry has to draw. Right? That's the question. And if it draws in favor of having a mecha body like that, then I think the body like that will only help, of course.
Thank you for your view. And with this panel discussion on copyright infringement and enforcement challenges is over. And I must say, and I must thank all the panelists. It was a great panel, great discussion. Thank you. And definitely we'll be taking it forward as well. Thank you.
Thank you so much.
Yeah. Questions? We can take questions, I think. Who's left? I think British left.
Oh, okay. Maybe since Novita is here, maybe she can answer as well. I think, I mean, I've been looking at this. Novita knows, for quite some time we have had these discussions. I was also involved in the discussion with Bridget's team on, taking things forward. Are we sort of concluding that ultimately when we talk about one is the infringement, which is of civil nature between two parties which are identifiable, trying to get damages and all of that to be sort of mitigated. And as Dr. Saraf said in the morning, in the Indian courts it becomes really tedious to reach that stage. But when we are talking about online piracy, which is willful, that kind of piracy, are we saying that just blocking the websites is the ultimate remedy that we are looking at? Or are we saying that we are looking at, as you said, money coming in? Now, when you say money coming in psychologically, if I'm able to stop, piracy, maybe I'm not losing the revenue. That is the way I'm thinking that money is coming in, or actually seeking the damages. For example, disclosures of ad revenue that you have made in some forum, and then trying to get that revenue back. The related question to that is because we have also noticed that a lot of these pirate, the origination may be outside the country. Yes. And we have had these situations where our own clients, located outside, yes, they are under legal restrictions from disclosing, yes, information of their own, citizens. If it is in India, maybe they can be persuaded, but because of MLAT and all of that, it takes a long time to sort of get that information, yes, right? So that's why I come back to the point, is the blocking is the real remedy we are looking at, and then the John Doe. Then the related questions, I know it's a multiple questions, but so that, you can sort of look at this. I was told by some of the producers that going for John Doe continuously to courts for every film, as you rightly said, becomes also very time consuming and also, costly. So is there a legal, simple mechanism that we can work out, which is quasi-judicial as suggested by Delhi High Court also, where you on the one hand take care of this blocking, but on the other hand also figure out, is there money coming in, or that is a done deal that we are not really thinking of money coming in. So just connecting all these points, if I can have your views, both of you. Yeah.
So on the site blocking initiative, what we have done is, we've kind of managed to secure a dynamic injunction. So, you may go in with a list of websites, but anytime if there's a slight domain name change, because these websites are viewed by the court as flagrantly infringing, that has kind of, expedited the process. And I think that should continue. I mean, if there are John Doe orders, there should also be these kind of, injunctions also that should be sought from the court. I clearly, I really want to advocate two things today, and also because we have some esteemed academicians. Somewhere we have to see that, the IPAB was abolished, right? And now all cases are going to different courts. And I think the Delhi High Court is being the first high court that has kind of dedicated intellectual property division. I think, sir, there can be some kind of a mechanism where all infringing cases are decided by one court. And of course, there are many other issues when it comes to licensing. We never spoke about it today, but like nobody is thinking today when it comes to any kind of statutory licensing or compulsory licensing issues, there's no IPAB, right? So it's going to literally commercial courts across the country. So to Gauri's point, I think it's a matter of doing both, but any kind of industry coalition, coming together, working with law enforcement, working with the advertising industry is welcome.
I think to just understand your question, the question that you were asking is that today, as far as your alternate mechanism is concerned, okay, we are looking at courts and going to courts and taking up that money and using, I mean, both time and money and having to enforce the right that way. And whether any alternate this is possible. I think yeah, I think that's actually a very proper suggestion, because I think that is the only way forward. Because if time and again you see the kind of there are two things to this. First of all, one is adjudication of your copyright, and the second is the enforcement of whatever that adjudication is, right? So now, if we are going to take so much time in the adjudication of it, and if it's going to be so cumbersome to adjudicate and say that yes, you have a copyright which you may enforce, then the enforcement of it remains one more tedious task, which in that sense copyright holders have to burden themselves with. So I think there has to be some kind of a mechanism where it's. I think the only thing that comes to my mind right now very readily is some kind of an ombudsman, where you have people who have, and the ISPs have to be a big part of this, where you have people who are sharing these websites, and see, the copyright infringers are many, but the ISPs are still not. I mean, still you can still have an account of them, saying that look, these are the ISPs. So if the ISPs, there is at least, if not, look, nobody is saying that the ISPs have to have criminal consequences for not discharging these obligations. But if the ISPs are at least obligated, even if not to disclose, because as your disclosure problems are there, I completely understand that ISPs cannot disclose. But as far as ISPs are concerned, they at least internally must address this issue of going to those users and saying, look, there is a problem. We have received a notice from the copyright holder. We are protecting you this time. We're protecting you twice. We protected you thrice, whatever number of times in a period of 3 months, 6 months, 1 year. And if you are beyond that, we are going to put you out. And the way you put you out is that the ISP comes and discloses it to this body. Let's say it's a tribunal or whatever it is. And the tribunal decides whether, okay, now this body needs to have its rights curtailed by curtailing the use of internet for that body or that person or that entity. And that has to be a cross-jurisdictional arrangement, where if there is such an order from a body in, let's say, England, then it will be enforced in India. Of course, China is a wholly different ballgame, but it will be enforced in India. If there's an order from India, it will be enforced in the US. And that is the only way to go up, because I mean, the borders are only territorial. I mean, the moment you get into the internet, there are no borders. There is nothing. So you see that with the crypto industry also, and that's the biggest problem that the crypto industry is facing today. As to how do you, if someone sitting in the US hacks a wallet in India, what do you do? What kind of orders do you obtain? Who has jurisdiction, and where do you enforce whatever orders you get? And who is this person who you're going to enforce it against? So if all of these problems are going to be, for your first headache is going to be, do I have copyright? Then that's where, I mean, a lot of copyright holders will be just disincentivized from, in that sense, enforcing. So I think if these mechanisms are put in place, and in that sense also there are specialized branches within a law firm that handle this. It's like, for example, I've seen that most commonly in SAT, for example, it's like securities litigation, where it's a very clear kind of where a branch of the law firm is just dealing with SEBI, and it's a very, SEBI goes and you argue before SEBI, and it's, people said, SEBI would always take a view which is for them and against regular, never be with a infringing person, but that is not true. Day in and out, SEBI is passing orders which don't necessarily hurt the person who is claimed to be infringing the regulations. So if you have those kind of mechanisms where, there's clear licensing between the copyright holders and this organization that she's which is like something like SAT or whatever it is, and through specialized channels which I feel have to be lawyers or legal law firms, it really helps set up a mechanism which will speed up and especially law firms that have cross-country presence. It really helps, where if you are also in the country which is where the infringer is, or where the source of infringement is, and you're in the country where you are, where this copyright holder is. It really helps you branch a lot of, it creates a lot of what like conduits which very help for easier infringement of copy.
I want to add something here. See, blocking access to the users is the first step, which is required if we have to minimize the infringement. And if the access will be inconvenient, like ISPs blocking many torrent sites, many other sites which hosts infringed content, definitely people will look for alternatives. And what we have seen in India, in recent years, OTT platforms have got a lot of acceptance. It was difficult to imagine, like 7 to 10 years ago, that people in India will be actually purchasing multiple OTT platform subscriptions. But now, yes, that is a possibility. So I think something like that, technological measures, if we take, that is always better, because when there are multiple jurisdictions involved, as I said, it will be problematic all the time, for the enforcement agency.
There's just one question. There's just one point that she had raised. Where are we talking about money that is from the websites, or are we talking about alternate economic benefits? I think it would be the latter, that is alternate economic benefits, because there's a lot of research in the US currently happening on it as to what the effect of these legal avenues are on simply a change in this whole dynamic. I feel as far as of getting money from these people are concerned, we litigate in courts where there is a human being, we know that there is a contract with that person and it is breached. We don't see solutions for years and years together. I mean, courts are highly overworked and are under a lot of pressure to dispose of things at the interim stage. So getting money out is, I think that's a parameter which I think the copyright industry should just not work with. I think you're much better off thinking that, how do I curtail this copyright enabling platform, a copyright infringement enabling platform, and I go for and I promote a copyright using platform and get a behavioral shift between these two through, of course, stricter enforcement and things like that. So that's it. Thanks.
Any more question from the audience? Yes.
My name is Rajen. I think this was a great session and first time happening in our country. I have not heard this kind of program in any country. So kudos to the organizers. My question is a little initially different, but then I will come to the specific ones. As a country of such a vast country, 1400 million Indians, all of us are creative. With mobile in hand, we can be highly creative. So problem one, we are not creative enough. Everybody is not creating copyrightable matter. So that is the main problem. The other part is we are not commercializing. In patent also, now we have started lodging some patents. There again, the foreigners are lodging more, and we are not commercially using it. Copyright as part of IPR was always in silo. It was sitting in Delhi someday, etc. So it was not part. Now it has become part in the last couple of years. So the issue is like this, which I have in my mind. Consumer law has initiated and all civil disputes go through mediation first. The process of lodging a complaint is very easy. You can do it on internet and then it is lodged and the offices have mediators attached and the problem goes to them. If it is not resolved, then it comes back. So for civil disputes, if we raise, today copyright is nothing but cinema and some successful books, etc. And cinema is also not successful. Out of 1,000 movies we create, perhaps 900 bomb. They don't make any, right? So what is the copyright over there? Because commercial value is not generated by the producers themselves. So coming to this, so mediation could be a great option. And this is an institution where we are sitting and we are, I think also we are making kind of recommendation, etc. So Consumer Protection Act 86, that has been now completely overhauled. A new act has come, Rule 2020. And there we have the commercial part or the civil part taken care of. So why not we have that kind of thing? The second part is the criminal part. India, we have about 152,000 police stations, and I challenge anyone, please check section 63 is not properly known even to the SHO of 10% stations. So what we have to do? Are we talking about Bombay-based copyright issues? What about the villages? 5,90,000, 96,000 villages. People can be creative over there because mobile is there. They can create entertainment. They can create any kind of a story, etc. And we have so much of folklore over there, so we can bring that. So we are bringing it, right? So police is not aware about it. Some issues come, and there are some very, very competent people. For example, Mr. Vijay Singh, he has spent 225 years in particularly this area. So some people are rare, they can educate others. So three problems. A, we should create more copyrightable material. We are not creating copyrightable material. We are not copywriting our work. That is a part. That is a major problem. And we are not commercializing that. That is the second part. Because if there is no commercialization, what law we will implement, what law we will create, that is A part. The B part is the civil part. And every small individual should be empowered to protect her or his copyright. Every person should be aware and should be able to defend and prevent others from using the copyright. Maybe it is a parody a person has created sitting in his or her house, etc. The other part is the police part, the implementation. And today, after IPTV has gone, commercial courts have not come into being, and it is impossible for a common person to go to High Court and get a matter readdressed unless you have very competent advocates who have been paid enough to run after your matter. Otherwise, you can't get anything done at any High Court, and that will prolong for a long time. So a few problems which, as a common people, we are associated with, and also the remedies in form of civil and also the criminal. And section 63, you can check. You can call police station, numbers are there. We can call in 2-3 days time 10 numbers in Tamil Nadu, in Uttar Pradesh, in Kerala, in West Bengal, Assam. They would not know what the section 63 is. That person knew only 66A, in which 7,500 FIRs were lost after Supreme Court had read down that section. After that, people were lodging left, right, and center. They don't know anything. They don't know 43. They don't know 67. They know only 66A. I don't know if today also people are lodging FIR and people are put behind bars under section 66 capital E. So the problems are commercialization, copyright material we are not creating, and the civil part, commoners, and criminal part, commoners. A lady who has created a song, she should be able to defend her copyright, civil as well as a criminal. That part is not happening. We are concerned with Ajay Devgan. He has got money. He can get 10 lawyers. Rohit Shetty can get anyone and get the matter sorted out. But what about the balanced people? That is the democratization. Mobile has made everybody empowered, aware. But are we really democratizing our intellectual property rights, particularly entertainment and copyright? So that is my issue before an August time. Thank you.
Any other question?
So you're referring to China.
Yes, yes, yes.
So I have visited twice, and I have seen both things there: genuine goods and fake goods, especially across the road, bookshops. How they are managing to run the show globally, and the power, global power also. Is the economic might is right? Yeah.
But a lot of times what happens is that as Mr. Brijesh said, there is this whole trend of viral videos. China has numbers more than economic mind. So so a lot of times a copyright holder, for example, let's say there's a person on TikTok. Yes, it's all IPRs, TikTok, or let's say trademark holder, or let's say let's say the person puts up a video on YouTube. Okay, let's say I put up a trailer on YouTube. as a producer, I put up a trailer on YouTube. Whether that trailer is viewed in India or it is viewed in America or whether it is viewed in China, a view is a view. And in the end, I can boast of 10 million views or 12 million views or whatever it is. So, there is also, so if there is a bunch of people in China who are viewing that, they are happy to let them view it, because in that sense, your movie is getting that kind of that kind of traction. But that again is viewing of this material, copyrighted material, and which is legal. So, so the line between the two is sometimes, in that sense, is there enough incentive for a person to go to China and go and have that enforced in China while rubbing a lot of, like you said, economic mind, rubbing a lot of feathers the wrong way? It does not make sense for that person. He'd say, okay, one country, I'm getting certain amount of infringement out of it. I'm getting some amount of benefit out of it. It's not worth my headache to go there and enforce this. But in a in a country where legal enforcement is more readily available, like India, or in that sense, Europe, you will want to enforce it and see to it that you maximize the amount of your the enjoyment of your right, and that's where the cards fall. I mean, pieces fall, and I think people accept it with China. That is where things are going to fall, and you let it go. That's all you can do.
All right, so we had a fantastic post-panel discussion also. So thank you to all the speakers once again.
Thank you so much.
Thank you.
Thank you, sir. May I now request Gauri Gokhale ma'am to kindly felicitate sir with a memento and a sapling. We would also like to thank Lohita ma'am and Brijesh sir for joining us virtually for the panel discussion. Thank you.
Thank you.
Thank you very much. First of all, on a Sunday, we have had these discussions. I was out in the mountains for 2 days, and thereafter to come and sort of get into this heavy conversation was very, very engaging. I think the one of the key purposes, and in fact, the way the conversation started was we were at a FICCI event where Justice Pratibha Singh was making her opening remarks, and she had suggested several things that we should consider in the context of enforcement of IP, and thereafter Sajid sir approached us to sort of organize this discussion, and especially in the context that DPIIT cell is attached to the college. So as lawyers at NISHITH DESAI Associates, we are always we have three purposes. One is of course doing best client work. Second one is to create socially conscious lawyers. So one of the key things is to do student education. So that is why I told Sajid sir that YouTube viewing should be available for this, and later on also this will be available. And third one, importantly, is to sort of work on the future of law. So that is the other purpose, and that's why we were constantly looking at, okay, what does it mean? We can't just discuss the issues, but what is the takeaway for us? And we plan to, with your college basically, and with the industry sort of inputs that you may want to give in addition to what we discussed, at least identify 3 to 4 key areas where the law should be revisited, whether it is Copyright Act, now the government is working on reworking of the Information Technology Act 2000. They are looking at new Digital India Act. So whichever legal tool that we want to use to sort of address these issues, we will be creating a report to present to the government. So anybody has any additional comments, please feel free to let us know. You have our IDs, and we will be working on that shortly, and we will circulate once it is presented to the government. So that is the sort of main purpose of a workshop, because sometimes when you do a seminar, discussions happen and then people go home, right? But the purpose of this smaller workshop is to sort of have more engaging conversation and have certain takeaways. So thank you all. Thank you, MNLU, for sort of being part of this endeavor, and we will be constantly working with your team to take these things forward. And thanks to all the panel members and whoever is present here and in absentia. Thank you all for contribution. And the last thing is to the students, whoever is going to listen to me, that always sort of look at law as not just what it is, but what it ought to be as well. So always think on those lines, and just don't study law for just, interpreting what is today, but also look at, what are the legal solutions that the law can provide. So and work towards that as well in your profession, maybe not initially, but later part of your career. Thanks a lot and have a good evening.